Going to turn on the microphone. Um, so please tell us the time that you believe that you need to argue, not the time that you would want, in a perfect world, but the time that you believe that you need. We spent the entire summer reading over your briefs, so we are totally familiar with your arguments. First case on the calendar, Tommy Davis.
Request 7 and 2.
727. Burchill versus the City of New York. 525. Matter of H children is submitted. Jarmuth versus Wagner. Hello.
Respondent, 5 minutes.
So there's no appellant. Did you wish to submit?
Yes.
Submitted. Thank you. Liu versus Safran.
Respondent request 5 minutes.
525. People v. Chase Leggett. 525. Philadelphia Indemnity versus Addison PHS. Hi. Who are you? Do you want to submit? Oh, you came from Albany? Oh, I have to go there next week. Yeah. Okay. So I'll give you 5 minutes for coming from Albany. Torres versus Rivera is submitted. People, no, I'm sorry. I missed somebody? Oh, Ringel versus Ringel. Thank you.
Plaintiff appellant, 5 and 2, but I'm not sure. Ringo.
Ringel,
5 minutes.
5. Torres versus Rivera. So there's no appellant. You still wish to argue? Okay, thank you. Submitted. People versus George Harris. 4, 1, and 4. Floor versus Lewis R. is submitted. United Services Automobile versus Mickens.
Good afternoon, Your Honor. I'm here for the respondent, but I don't see an appellant.
So would you like to submit?
Unless the court has questions, we'll submit.
Submitted. Thank you. Deco Towers versus Fish. 5, 1, and 5. People versus Kenneth Cologne is submitted. Mejia versus Linares.
7 and 2 for appellant, Your Honor.
Respondent, 7.
626. That case is going to be called first. Barash and McGarry versus Markowitz.
Appellant, 8 and 2, Your Honor.
Respondent, request 8, Your Honor.
8, 2, and 8. People versus Terrence Jones. 4, 1, and 4. People versus Saul R. is submitted. Bolaro versus Lido.
Appellant, 6 and 1, Your Honor. Respondent, 5, Your Honor.
Yes, 5, 1, and 5. People versus David Rivera is submitted. Mojica versus the Church of the Immaculate Conception is submitted. Seltzer versus McFadden is submitted. First matter for argument, Mejia versus Linares. Whenever you're ready.
Good afternoon, Your Honors. Jacob Tabor of Perkins Coie for the appellant, here to present for oral argument my colleague, Mr. Michael Houston of the District of Columbia.
May it please the court. Now that this court in Brooks has confirmed the enforceability of the click-wrap agreement that's at issue in this case, plaintiff primarily shifts to arguing that the contract between himself and Uber is unconscionable and invalid for that reason. That argument is wrong for three principal reasons. First, the parties to this contract expressly delegated that issue to the arbitrator and not the courts. And the Supreme Court of the United States has explained that that is a separate and enforceable arbitration agreement under the Federal Arbitration Act. Second, plaintiff primarily argues that the contract is unconscionable because Uber circumvented his attorneys. The record shows that that's not correct at all. Uber gave notice to the plaintiff through its demand for arbitration that it was seeking to enforce the terms of this contract. It provided a complete copy of the applicable terms of use to the plaintiff. The plaintiff at that point had, and it provided them, I should say, to the plaintiff's counsel.
So we're talking about the 2016?
No, Your Honor. We're talking about the operative contract. I mean, there was a contract in 2016. The operative contract is the contract that the plaintiff entered in January of 2021 through the click-wrap interface. That's exactly the same click-wrap interface that was at issue in this court.
So now the click one, that one, there was a hyperlink, right, that actually took you to the terms and conditions?
That's correct, Your Honor. There's a hyperlink provided on the interface that says, we encourage you to review our updated terms in full. They're available at this hyperlink. Again, same interface that the courts found gave rise to an enforceable contract in Brooks. I don't actually think...
What's the difference between the 2016 and the 2020 agreement?
So there's a slight difference in the interface, Your Honor, in the presentation. In 2016, the terms were presented at the time that the user was signing up. So we said to the user, please give us your information, your name, email, address, your account, your phone number, things like that. And then at the bottom of the page, there was a link that said...
But in terms of the arbitration part of it, there is a difference from the 2016 to the 2021, correct?
There's a difference in the terms of service that applied in 2016 versus 2021. That's correct, Your Honor. I think the 2021 terms, which are the more recent terms, which are the ones that the plaintiff agreed to in January of 2021, say that they supersede all other agreements. So I think Brooks establishes that the interface that the plaintiff used to form the contract in January of 2021 is enforceable. That means that
This accident was in 2020, prior to the 2021 terms.
That's correct, Your Honor, but the 2021 terms specify that they are going to require the user to arbitrate all disputes that he or she may have with Uber, whether they arise before or after.
That term is different than what was in place in 2016.
Well, I believe that's correct, Your Honor. But again, I don't think it matters because when it is standard contract law that if there's a pending dispute, or not a pending dispute, if there's sort of the possibility of a claim that hasn't been asserted in court yet, but that could conceivably be asserted, the plaintiff is, of course, free to make a contract about how that is going to be resolved. That's what we had here. The plaintiff agreed in January 2021 that he would arbitrate all disputes with Uber, whether they arose before or after the time of signing the agreement. So
But at that time, he had an active case.
No, respectfully, Your Honor, that's not correct. He had not brought the litigation. The litigation was not filed until after the plaintiff had signed the 2021 click-wrap agreement. I think what Your Honor may be...
That made a difference?
I don't think, in all candor, Your Honor, I don't think so. No, it would not make a legal difference. But it's not correct as a matter of law for the plaintiff to suggest that,
It sounds better if he signed the arbitration agreement before he started the action.
I think it makes it somewhat...
Sounds better for you.
I think it makes it a somewhat easier case for us, Your Honor, the fact that there was never any litigation pending at the time that the plaintiff filed this, at the time that the plaintiff entered this contract. Even if there had been, it would still be enforceable because parties are capable of making contracts even after they've entered litigation.
So in terms of enforceability of the contract, plaintiff points to Castro versus Gem Leasing. Does that not control the issue here?
No, Your Honor, for two principal reasons. First, the Castro decision, if anything, would be relevant only to the 2016 terms. This is about the 2021 terms. Again, the second and successive contract that was entered, which is governed by the court's decision in Brooks. I think perhaps even more important, Castro is not applicable here because the point of the court's decision in Castro was that the parties in the Supreme Court had not put the user interface in the record. This court said, we don't have the means to judge whether the 2016, or I shouldn't say the 2016 interface, but whether the interface that was at issue in Castro gave rise to an agreement because it's not in the record. Of course, we don't have anything like that here. The interface is part of the record, as are the 2016 terms themselves. So
And you submitted a screenshot of the, part of the record is a screenshot of the 2016?
that's correct, Your Honor. I can it's certainly cited in our brief. I can provide you with the page citation if you prefer. I think it's important to note that the thrust of the plaintiff's claim in this case is that Uber somehow circumvented his attorneys. And if I could just explain for 1 second why I think that's really not consistent with the record. The first point is that it was plaintiff that reached out to Uber in January 2021 and said, I'd like to use your services. And Uber responded by saying, that's fine. We're going to offer you the exact same terms of use that we offer to all standard U.S. customers. That's
I guess the point that I was trying to make is that in March of 2020, after the accident, his attorney had sent notice to Uber that there was going to be a pending lawsuit. And yes, as you have indicated, the plaintiff then decided that he wanted to continue using Uber and entered into this 2021 terms.
So I would just respectfully disagree with the premise of Your Honor's question that the plaintiff had notified Uber that there was going to be a lawsuit. I would encourage the court to look at record 99. This is what the plaintiff said, and only this, quote, our client, Gustavo Jesus Mejia, was a passenger in an Uber that rear-ended another vehicle. That was submitted through an online portal to Uber requesting insurance information. Uber responded at record 97 by providing the independent driver's insurance information. I do not think that comes anywhere close to asserting a claim against Uber or suggesting even that there's going to be a claim against Uber as opposed to the independent driver or the other driver that was involved in the accident.
When was that submitted through the portal?
Excuse me, Your Honor?
When was that submitted through the portal?
It was, I believe, March of 2020, Your Honor.
Thank you.
Thank you.
Good afternoon. May it please the court, my name is Aria Lieberman for the respondent. So the timeline has been laid out, as Your Honors have already stated. February 2020 is the accident. In March 2020, our firm put Uber on notice of our retention. 10 months after that, Uber causes an in-app pop-up screen to be on Mejia's phone.
Well,
Yep.
respectfully, he went into the app to use Uber's services while this whole situation was pending.
That's correct. He used the Uber app to get a ride. He didn't open the Uber app to try to change the terms of his lawsuit or to change the ability to sue.
At the heart of all of this is a question as to whether or not someone can be bound through electronic notice, right?
Well, respectfully, this court already did determine in Brooks v. Yang, and which I've cited, and it is held that the updated terms do constitute a binding contract, and this court has already held that. So I'm not trying to challenge that. But this court did leave open that decision, the unconscionability argument, because the plaintiff in that case never argued that below.
So here's a question. So to the extent that the later agreement, the 2021 agreement, says that the I'm referring to record 116, paragraph 2, A. It says here, this arbitration agreement shall be binding upon and shall include any claims brought by or against any third parties. I'm sure you're familiar with this. How do we view, how do we evaluate the fact that the plaintiff not only accessed the app after the accident, but also after the lawsuit was filed, and after the motion to stay the arbitration was filed, and used the app most recently in 2021. I mean, there seem to be 4 different times when there's been shall I call it a de facto ratification of the terms of the click-wrap agreement?
So this goes to the appellant's argument where they cite to a federal case, Nicosia, which stands for this proposition that the continued use of a service means that the person continued to assent to that. And Nicosia is distinguishable for a few reasons. Most notably, that case involved Amazon. When you purchase something on Amazon, and in one of the Nicosia decisions explains this, next to each time you purchase it, every single time it says by purchasing you're agreeing to the terms and conditions. That's just not the case for Uber. So that, number one, is distinguishable. Number two, Nicosia relies on Washington state law, not New York law. And number three, of I think extreme importance, it's never been cited approvingly by any appellate court in New York
But here, admittedly, the plaintiff had options other than Uber, right?
Yeah, and defense counsel, for the appellant brings this up. Oh, he could have taken public transportation. Well, with all
Could've taken Lyft.
or a Lyft, potentially.
Competitors.
Just with regards to public transportation first, my client was severely injured in a motor vehicle accident due to negligence.
Well, see, that's why I mentioned Lyft, because what I was trying to get at was that it was comparable, right? Uber and Lyft are comparable in terms of ride shares, right? So that's the issue. That's one of the issues.
Well, I feel like, and with all due respect, I feel like this is kind of like a side issue because the case that they rely on, I don't believe it to be binding to this court.
So let's take a look at Nicosia in terms of Amazon. Is that what is controlling the fact that in that case where that individual used Amazon on a continual basis, that pop-up stated that you're agreeing to the terms and conditions? Is that what dispositive? That was there when you go on the Amazon app as opposed to here in the Uber app?
In my reading of Nicosia, that's the dispositive difference. And also, it's not binding on this court. So I think between those two, that's both distinguishable and not binding. I don't think this court should follow that rationale. Rather, I think this court should follow the rationale from the Salgado court that I cited in my papers. In that case, a individual, a restaurant employee, had counsel, and the employer went behind that counsel's back and got the employee to agree to arbitration. And the court in that case said that was unconscionable. You can't be, if you know that attorney is out there that represents the client for this exact issue, you can't go around that attorney's back and change the terms of the agreement.
What's so confusing here, counsel, is that the plaintiff uses the app even after the lawsuit is filed. So the plaintiff ostensibly is on notice that there's issues with respect to the click-wrap agreement, and notwithstanding that, the person goes and uses it, I believe, 2 times, 3 times after the lawsuit is filed. How do you explain that?
Well, again, we're dealing with the accident occurs in February 2020, and then the terms that they're relying on are in January 2021 when he clicks on something in the app, right? The fact that he then later requested rides, where he doesn't again have to click I agree to these terms or click anything, he's just requesting rides in the app. I don't think that provides further sense, especially when here he's contesting that's a valid agreement.
Why, if you're not continuing to use it and you're continuing to request rides, why does that not constitute your acceptance of the terms and conditions?
I think here he's contesting that it was ever a valid agreement to begin with. So how does it further bind him? Just because Uber's arguing that it's an arbitration agreement, that binds him? Supreme Court below agreed with Mejia's position that this wasn't a binding agreement. So I don't think that's fair to say, Uber argued it's an arbitration agreement and he continued to use it, so he must agree too. He doesn't agree it's an arbitration agreement.
Thank you.
Thank you.
Thank you, Your Honor. I'm glad that several members of the court brought up the Nicosia case. I also wanted
Well, actually, your adversary brought it up.
I'm glad that the court had an opportunity to discuss the issue. I also want to encourage the court to take a look at the registered.com case, also from the Federal Second Circuit, that discusses the same principle. It's a really simple principle of contract formation. If a party has actual notice of the terms of a contract and they accept the benefit of that contract, that is acceptance of the contract terms by conduct. It's not unique to ride sharing or even to digital contracts. It's just a standard principle applied to this kind of context. And what we see here is that we provided Uber, we indisputably provided the plaintiff with a full and complete copy of both the 2016 and the 2021 terms of use. Plaintiff had actual notice of those terms through his agent. The terms of use are clear as they can be at record 115, that by accessing or using these services, you confirm your agreement to be bound by these terms. The plaintiff knew the terms of the bargain, and he thereafter used the Uber app multiple times. That's acceptance. Just like he can't accept the Uber rides and refuse to pay for them, he can't accept the Uber rides and refuse the arbitration agreement that the parties entered into. My friend says that this agreement is unconscionable by analogy to the Salgado case. I think if the court takes a look at the facts there, you will see that it is extremely different. The defendant in that case threatened to fire the plaintiff from her job on the spot if she did not agree to arbitrate a dispute. That's what procedural and substantive unconscionability looks like in this court. This is nothing like that. This is the plaintiff coming to Uber and saying, I would like to use your service, and Uber says, we're going to offer you the standard terms and conditions that we offer to all other customers. Those are the AAA consumer arbitration rules enforced by courts all across the country. I think this state's strong public policy in arbitration and the terms of the Federal Arbitration Act, which requires, of course, arbitration agreements to be enforced according to their terms, both strongly suggest that this court needs to uphold this contract. Thank you.
Thank you. Thank you all. People v. Tommy Davis. You may proceed.
May it please the court, my name is Scott Cohen from Cravat, Swain & Moore, and in conjunction with the Office of the Appellate Defender, I represent Tommy Davis as pro bono counsel in this appeal. Mr. Davis was deprived of a fair trial 5 years before it ever began. That happened when the court below consolidated two factually unrelated...
Counsel, the court below, they granted consolidation under what sections?
Under both section 200.20 B and C, Your Honor.
And I take it you're saying that that consolidation was improper?
That consolidation was improper.
And can you tell me why as to, under each section?
Under section, for both of the sections, under section B, because there was not a sufficient factual nexus that would support any material admissible evidence that would go towards both the attempted murder and the possession count. And under section C, it was an abuse of discretion to consolidate because the prejudicial effect substantially outweighed the probative value of consolidating.
Did the lower court make any finding with regards to the prejudicial effect versus the probative value under subsection C?
No, Your Honor.
Was the court required to?
No, the court was not required to, but in its analysis was restricted to only 2 paragraphs.
In fact,
But counsel, the 200.22 subsection C was raised in the defendant's motion, wasn't it?
It was raised in the defendant's motion and then again right before trial.
And the reasons why the cases shouldn't be consolidated were listed by the defense counsel, right? That a joint trial of the cases would discourage the jurors from considering separately the proof as it relates to each case, that the proof was different and weaker in one indictment as opposed to the other, that the defendant had put forth a justification defense with respect to one case but had no interest in testifying in the other. All of these concerns were raised in the defense motion, weren't they?
That's correct, Your Honor. And the court below plainly abused its discretion by consolidating these indictments nonetheless.
Wait, so counsel, I just want to get back to the other point. Is there anything under subsection C or subsection B that talks about an analysis of the prejudicial versus probative value?
No, the court has broad discretion under subsection 5.
Okay, so my colleague asked you about whether there was any analysis in the court's decision concerning prejudicial value, and you said no.
That's correct, Your Honor.
Okay, so are you asking us then to reverse the convictions based upon the fact that the court did not undertake an analysis of prejudicial versus probative value, of the prejudice that would inure to consolidation?
No, Your Honor, we believe the record speaks for itself that the prejudice was evident from the very nature of the, I'm sorry, Your Honor.
No, go ahead.
That was evident from the very nature of the prejudice at stake.
How? How is the prejudice evident?
And I shouldn't answer a question.
No, I'm asking counsel, how is the prejudice evident?
Because the defense's justification was that there was no, the defense's main theory was that Mr. Davis did not have a gun, and the consolidated second indictment was solely for possession. And so,
With intent to use unlawfully, though. Was one of the charges with intent to use unlawfully?
with intent to use unlawfully. That was an extraordinarily weak count, and it was...
Yeah, but yet, well, when you say it's extraordinarily weak, it's sort of, isn't it a counterintuitive point to the argument you're trying to make? Because if it's extraordinarily weak, all the more so that there's something to the people's theory that they needed a 2010 charge to support what they were saying about the 2011. And what Supreme Court said was, furthermore, the evidence of possession of a firearm on October 7, 2010 would be relevant and admissible to prove the defendant's possession of a weapon on March 12, 2011 under the theory that he intended to use the weapon unlawfully against another.
That is what the court said, but that was not what ended up happening in this case,
I
Your Honor.
understand you disagree with it, and I'm no doubt that reasonable people can have different points of view on this, but was it an abuse of discretion for Supreme Court to come to that conclusion?
That would have been a basis for that's the basis for the consolidation. That's why you consolidate the charges, right?
Yeah, I do believe it was an abuse of discretion for the court to come to that conclusion purely because of the facts of this case and what needed to be argued and how it would create a propensity inference as to the attempt.
The evidence of the 2011 charge was far more compelling than the 2010 charge, was it not? I mean, there was some recorded phone call of the defendant. Could you tell us what that was about?
There were recorded phone calls which Mr. Davis knew were being recorded, and there was barely any probative evidence as to either.
So what did he say in those phone calls? What did he say to his girlfriend in that call?
Depending on which phone call you're talking about, he mentioned that in call 6, for example, that he was aware that he had been indicted for attempted murder. But I do want to point out that
Doesn't he at some point say that was his gun?
No, Your Honor. The language that respondent points out is, he said, I'm glad I got that off of me.
Well, he says that the police officers claim that the gun was passed to him, or he passed the gun, but he says, but they couldn't have seen me passing the gun, something like that. So he kind of admits that he was at some point in possession of the gun, because he was arrested with another gentleman, right?
Respectfully, Your Honor, I think that the phone calls were not that inculpatory. They were vague.
Well, let me just jump forward to during the trial, particularly the April 18th, 2013 transcript, when they renewed this application, maybe to sever the charges, the trial at that point. And at that time, was the judge required to make a new finding? Because in the transcript, he simply says, well, I've already thought about that, and I'm not changing my mind, something to that effect. Was he required to make a new finding at that time?
No, Your Honor, the judge was not required to make a new finding, but as you bring that up, the judge had noticed that it should have given a limiting instruction, and it never did, and that forms a whole other basis for error in this case.
So why didn't defense counsel ask for that limiting instruction?
that was error, and we argue in our third point that it was an ineffective assistance.
Doesn't that require a 440 motion?
It doesn't, because as you...
It does not?
It does not. On the record, it's plain that that was clearly an erroneous analysis of what needed to be
Was
done.
that error harmless?
I'm sorry?
Was that a harmless error analysis that maybe we should take based upon,
There certainly was no harmless error, especially in light of the fact that the first trial ended in a hung jury, and so this propensity inference that the jury
That
no
was, the
doubt...
first trial was as to which charge or charges?
All of the charges, except there was a superseding indictment in 2016 with a special information about a previous crime, they were all the same. So the trials were substantially similar. The same evidence came in, except for one witness, and the jury was not able to reach a conclusion beyond a reasonable doubt.
So aside from the evidence of the shooting, what evidence, if any, did the prosecution present to establish in the possession case intent to use unlawfully?
It was only the evidence of the attempted murder in the first indictment.
Aside from that, anything else?
They argue in Call 6 there was information about the attempted murder, but it was only Mr. Davis acknowledging that he had been indicted for attempted murder. There was nothing probative in those in the Call 6. I see that my time is up. I had hoped to touch upon sentencing if I could bring that up.
You can do so in rebuttal. Thank you.
Good afternoon, and may it please the court, Faith Petrolio for the people.
Also, I'm going to ask you to answer the same question I asked the adversary. Besides the information about the shooting, what evidence did the prosecution present about the intent to use unlawfully with regards to the possession charge?
Your Honor, I believe that was the main evidence as...
That's the only evidence?
Yeah.
The phone call?
No, the shooting.
Right, I believe that's correct.
So you're not even relying on the phone call as evidence of intent to use unlawfully in the possession case?
I believe the main evidence was the shooting in terms of his...
So he must have had the intent to use unlawfully because he ultimately shot at or two people.
He previously shot at two people.
Excuse me. He previously shot at two people. So that in 2010, so that means in 2011, when he has this weapon, he must have had it with the intent to use unlawfully.
Right. In addition,
and that's it.
How is that not a propensity argument?
Well, Your Honor, first of all, I just want to emphasize that these are two independent grounds for consolidation that should be analyzed separately. So we're talking about 2B
okay,
right
so
now.
we'll get there, and I'm going to let you do that. But you do say in your papers that the court consolidated based on both grounds, correct?
That's correct. Okay. So for this argument for 2B, I believe that we argued in our papers below that because defendant was involved in the shooting in 2010, he would have possessed the gun unlawfully in 2011.
How do you make that leap? Is it the same gun? Is it from the same transaction? Is it a continuing transaction? It's 2 years later, different place, different gun, nothing connected. Connected for me.
I think the connection that the people were trying to make at trial, which obviously the jury didn't believe, was that the defendant had the second gun in the 2011 incident when he was arrested, in case he was in fear for his life in a reprisal for the 2010 shooting.
How do we get there? There's no connection between the folks in 2010 there's no connection between the incident. Is there anything that he's being followed or he believes that there's going to be retribution because of what occurred with the two individuals in 2010? They were like superintendents or something. He was an assistant superintendent, and they thought that he was taking over their job, or they were taking his job.
Right. I believe that defendant did argue in his omnibus motion that he had possessed the gun in the 2011 incident where he was arrested for justification purposes, and that he had intended to raise a justification defense at trial. That's what he said in his, I believe, omnibus motion right at the beginning of all of this.
It seems to be there is an argument to be made that we're talking about propensity. So if in fact we're talking about propensity, why then should there not have been a charge, a specific charge, given to the jury as to the separation of charges, as well as to ensure that that the jury was not convicting based upon propensity?
Well, first of all, Your Honor, that claim is unpreserved, as defendant acknowledges. Additionally, we can be sure that the jury did not make that.
It can be unpreserved, but as a trial judge, you have to make a determination as to, although it is not requested, that you at least ask whether or not the defense would like such a charge read, or you believe that a charge should be read, or you ask the defense, should a charge be read?
Right. The jury instructions were provided to defense counsel multiple days in advance, and defense counsel did approve them. Additionally, we can be sure here that the jury didn't make the improper propensity inference, because they did acquit him of the charge.
We don't know why they acquitted, right? We never know why a jury acquits on certain charges and convicts on other charges. So can we really make that determination that the reason they acquitted on that charge was because of, I don't know, a lack of evidence on that one, or whatever?
Well, Your Honor, the people never made this argument in summation that the jury should rely on the first evidence from the first indictment to convict in the second.
We don't know why the jury did it, but it's an indication that the jury did not take the leap that because he did one, he did the other.
Yes, Your Honor, precisely. I just want to also touch on.
But that just doesn't seem right, because if you have no other evidence of his intent to use unlawfully other than the shooting, that's exactly what you're telling that jury, and they may not have used it for that purpose, but they could have used it for any other purpose, i.e., he possessed the gun in the first one.
Well, Your Honor, to that I would argue that the jury had no reason to make that kind of reverse inference. There was direct evidence in that case. We had 2 eyewitnesses. There were ballistic evidence. There was video of defendant on surveillance going in and out of the building that day.
So are you arguing that if consolidation was granted improperly, that it's harmless error?
Yes, Your Honor, but I would also like to touch on.
So how could you possibly say that when the rearrest on new gun charges, which involved a different weapon, occurred only 6 months after the 2010 initial arrest?
Well, I would say that these are different guns. They're in different locations. They involve different witnesses. And so the jury was clearly able to segregate these 2 bodies of evidence, which.
How? How? Without a limiting instruction, how?
Because you're saying that the resulting acquittal on that charge meant that they did not consider the attempted murder in terms of the intent to use unlawfully.
That's correct. But I would say that because the bodies of evidence for each indictment were very different, and they might have only been 6 months apart, but they involved completely different locations, witnesses, different guns even. And for that reason as well.
Why isn't that a reason? I'm just going to go back to the April 18th, 2013 transcript when the request was made to sever the trials. Why isn't that a reason in of itself to have granted that at that time, as opposed to the trial judge just sticking to, I've already thought about this, that's it?
I'm sorry, what was the reason?
What you just said.
Oh, I'm sorry. Well, I think here, in terms of severance, under 2C, first the trial judge could not sever under 2B. If they're properly joined under 2B, then the trial judge could not.
So you're saying it was properly joined under 2B or 2C? Which one?
Under both. But under 2C, the trial judge could sever them if.
Under 4, right?
Under 220, subsection 3.
Well, we're talking about severance. Go ahead, because I think you have the numbers wrong, but go ahead.
Okay, I apologize. So under subsection 2C, the judge could sever if he felt it was necessary, but to do that, the defendant would have to show good cause, such that there was substantially more evidence in one indictment than the other, and that the jury would be unable to segregate the proof from the 2 indictments, and defendant failed to do that here. So that's why in the transcript you're referring to, the trial judge did not have to sever in that particular instance.
Was there any attempt by the defendant to show good cause?
Yes, I believe in his motion papers he did bring up the good cause elements, but they were just mostly pointing to the fact that the people had different and weaker evidence for each.
Basically, he claimed that there was prejudice, right?
Essentially, yes.
Well, not essentially.
Yes, he was claiming prejudice, but the trial judge in this case clearly felt that that there was no risk of prejudice, and so properly consolidated these cases. I see my light is on. If there are no further questions.
Thank you very much.
Thank you.
Very quickly before getting to sentencing, I want to address my adversary's statement that the nexus between the two indictments was this idea of reprisal, and that's why he had the gun. Not only did they...
Well, that was speculation. I mean, go ahead. I'm sorry, go ahead.
Not only did they not argue that at trial, but in summation, if I could point your honors to transcript 620, the argument was actually pure propensity. He said, the fact of the matter is defendant is a fugitive from the law and he's walking around, has a gun, a loaded gun. You may consider the evidence of how defendant has used guns. We submit, your honor, that this is a call for the jury to consider the propensity evidence, and for that reason, the trial was fundamentally flawed. And we would ask that the convictions be reversed. Alternatively, we would ask that this court exercise its considerable discretion to reduce Mr. Davis's sentence from 25 years to life to 20 years to life. Importantly, this would still permit the Board of Parole to have complete discretion as to when and how it would release Mr. Davis, but he would at least be given the opportunity at the age of 74 to seek release. Statistically speaking, he is very unlikely to reoffend at the age of 74, and if he is released, it would be to a supporting family and community.
He was a persistent, is that correct?
2 priors, yes, your honor.
And he could have, the judge could have ran the sentences here consecutively, right, and did not.
Yeah, and the court below took that into consideration, and certainly this was still a life sentence, an indeterminate life sentence, and we are aware and we think it's fair that the Board of Parole be given the opportunity to release within
It's a persistent violent felony.
with weapons, your honor.
He discretionary persistent.
I'm sorry?
Well, he wasn't a discretionary persistent. It was a...
No, he wasn't. But I do want to lastly point out that nobody was injured in either of these incidents. Consequences do matter, and 25 years...
The first one was sheer luck, right?
It was sheer luck, but as now Chief Judge Rowan Wilson said in People v. Garland, even by sheer dumb luck, that is something to take into account in sentencing, the fact that nobody gets injured. That's often a very relevant aspect, and for these reasons, in the interest
Well,
of
it was
justice...
sheer luck because it hit his cell phone. I mean, you know, it's not like he missed. He didn't miss. It just hit his cell phone, right?
Sheer dumb luck, Your Honor.
Wow.
And of course, the theory of the defense's case is that the gun was not in Mr. Davis's hand when that happened. But for these reasons, we would ask that the court reverse the convictions or alternatively reduce the sentence from 25 years to life to 20 years to life.
Thank you. Thank you both. I'm sorry? Oh, yes, counsel, you're pro bono, so I thank your firm for allowing you to take on this case.
Thank you, Your Honor.
Barkhill versus the City of New York.
May it please the court, Sophia Uvedov, Erkana Feld for the defendants, City of New York and Consolidated Edison. I will begin addressing the Labor Law 241-6 claims against the city. As the court knows, all 241-6 claims against my other client, Con Edison, were dismissed below based on the same Public Service Commission exemption that I'm going to be discussing today.
So the issue is the industrial code. So is it applicable in this matter?
I'm so sorry, could you repeat?
I said the issue is the industrial code, right? So is it applicable in this instance to the city?
Yes, correct. We believe that the plain reading of 113A was misconstrued by the court below, and that it applies to operations under the authority of the PSC, whereas the court below only limited it to the entity. And if I may begin with basic first step of statutory construction, which is the plain text of the regulation, Industrial Code 113A, titled Operations Subject to the Jurisdiction of the Public Service Commission, and it specifically provides that this section shall not apply to or in connection with operations conducted by the employers, owners, and contractors subject to the jurisdiction of the PSC.
So the plaintiff asserts that the city would be liable because you own the roadway.
Correct. We were the property owner under this Labor Law 241-6 claim.
Right.
Now,
Where does Con Ed, you represent Con Ed too here, right?
correct.
So where does Con Ed come into this?
So the project was actually part of the bigger city project to install
Is
water.
Con Ed saved, if you will, by this PSC provision too?
Correct, and it was dismissed based on this PSC provision. So the city of New York wants to install some water mains throughout the city. To do that, Con Edison needed to reroute conduits that were blocking the path. So the city hired the contractor Waterworks to do its water main, and that is planned.
And then they make a second contract with Con Ed.
Correct. Because Con Ed is required to move its conduits for the waterwork to proceed, Con Ed makes a second contract with Waterworks to reroute their electrical conduits. So the contractor, plaintiff's employer, Waterworks, is there both rerouting the electrical conduits so the city can proceed with the water main project. And there is some dispute between the parties on whether this court should classify all of this as part of the bigger water main project or as just part of the interference work that Con Ed was doing. But our position is if the court adopts 113A and reads it appropriately as applying
So it's
to...
your position that 241-6 is out of the case, both against the city and Con Ed because it's Public Service Commission.
Correct.
So that leaves us with the Labor Law 200 case,
Correct.
right?
Yes.
What is it that you have to say about that?
So as to the city of New York, our position was that that should have been granted. When the city moved below for summary judgment on 200, the plaintiff did not oppose it. It opposed solely as to Con Edison. That, under well-settled law, should mean that it was abandoned and it should have been dismissed. Now, if you would like me to get into the merits of...
So under the 200, was there any actual notice to the city of any defect? No, of the dangerous condition?
Well, the only evidence the trial court noted below is that there was a city inspector on site. It doesn't mean that they were aware that plaintiff was working in that particular area. It doesn't mean that they were aware of that particular conduit. They clearly did not control the means and methods of the work. So they had no actual notice of the specific dangerous condition that is alleged.
You're saying that the plaintiff is not really opposing the city as to Labor Law 200. What about Con Edison?
It did oppose as to Con Edison, and we do address the allegations. So as to Con Edison...
So why wouldn't Con Edison be potentially under Labor Law 200?
Well, we do provide the analysis under both means and methods and dangerous condition. Under means and methods, Con Edison, actually the plaintiff's deposition was clear that his immediate instructions always came from his waterworks foreman. So there was no direct instructions from Con Edison on how to perform the work on the day of the accident.
Did Con Edison have someone there on a daily basis, and did Con Edison also give him direction?
Con Edison did have people there on the daily basis. They did not communicate directly with the plaintiff. If they had communications, it was with the
Doesn't the
waterworks.
plaintiff claim that he did get direction from Con Edison personnel?
He
And does
claims
that set up an issue of fact?
he claims that the directions were used as an intermediary of his supervisors.
Didn't the plaintiff's foreman also testify as to the Con Ed supervisor, that the supervisor for Con Ed would sometimes direct the, instruct him as to the daily operations?
Not plaintiff in particular, but Con Ed would tell them things like you should use
Hand tools.
hand materials rather than heavy equipment at this area. This was all done in coordination to make sure and to reduce the risk.
So doesn't that create an issue of fact?
Under the case law of this court, having general supervisory authority is insufficient to control the means and methods. Nobody from Con Ed on the day of the accident was telling plaintiff what to do, how to approach this particular PVC, which equipment to use, and which gloves, if not, to use. The only conversation he had on the day of the accident was with his foreman.
Do we still have an issue, however, as to Con Ed and the installation of the electrical cables themselves, in terms of whether the cables were padded or whatever, and in terms of whether they were in any way guarded?
So that's the alternative theory, that there's a dangerous condition, partly that Con Ed did not de-energize its cables. Now, with the industrial code sections not being applicable because Con Ed had to follow the PSC regulations, that reg requiring them to de-energize does not apply. So now they're pursuing a common law theory that would require them to de-energize. And this court, back over 60 years ago, said it is just not practical, and we're not going to impose a duty on an electrical utility to de-energize its cables whenever it's doing excavation in the city of New York.
Is it clear whether this is, as the Con Ed, a means and methods case or a defective premises case?
We analyzed under both because the court did below, but I believe it would be more appropriate under the means and methods.
Thank you.
Good afternoon. Christopher Drake from William Schweitzer and Associates. I'd like to start with the appellant's attempt to invert, in a way, their non-delegable duty under 241-6 by using the exemption applied to public utilities and attach it to the city. It's very important to note in this case that the Con Ed line was not the purpose of this project. It was just interference work for an installation.
The term operations, because I see where you're going with this.
Yeah.
The term operations, is that ever really defined in the public service? I mean, are we to interpret it broadly?
No,
or
but it's been
narrowly?
but it has been interpreted to specifically mean, and my plain reading of the statute is the actual operation, the delivery of the utility. In other words, the delivery of the electric. In fact, I didn't really see it below, but in their appeal, they try to extend it to the water main as well. But this also was not operation of the water main; it was an installation of a water main. So, with respect to the ownership aspect of the city, it wasn't the city's line or duct, it was Con Ed's. With respect to the water main, it was an operation. Okay, so I don't think that the public service exemption applies to the city at all. If I can turn to the questions
Counsel,
about...
what about the city's water distribution role? Doesn't that come under the aegis of the Public Service Commission?
If Mr. Burchell had struck a water main while it was being operated, and that's what exploded in his face, perhaps. But here, they didn't have to shut off or interrupt service of water.
So you're asking us to construe or construct the word, construct, define the word operation very narrowly, aren't you? Because when we talk about water distribution, that's a very far-reaching term. It could...
Well, I would say distribution, meaning the water actually being distributed. Well, this was not an ongoing active water main. They were installing water mains. That's why this is really akin to an excavation operation.
Between a water main and water distribution.
Well, again, that's why we agreed with the defendants in the court below that Con Ed did not have applicability based on the exemption because it was in use, okay? And the purpose of the exemption is to not interrupt.
I thought this was a project to replace the water main on Amsterdam Avenue.
They were installing new mains.
Right.
So they're rerouting. So this didn't have some interruptive effect on the water itself. And specifically the project that Mr. Burchell was doing on the day of the accident was interference work for Con Ed, although it was indeed part of a larger project itself. So the city, to take Con Ed's ownership and operation of those electric lines and attach it to the city to avoid a liability on a 241.6, I think that's the leap. They're really trying to invert the city's obligation as an owner of the property and the contracting owner under 241.6, their duty. Turning to 200, just with respect to the fact that they claim the plaintiff abandoned the 200 claim against the city, they didn't meet their burden. And that's what the court was relying on. Whether or not we addressed it in opposition, the sufficiency of their papers is what the court was addressing, which is the fact that the city had an inspector on site and the inspector was observing the work taking place. With respect to the city's notice—
The city inspector or the Con Ed?
The city inspector. The city had an inspector on site.
The city inspector didn't have any expertise
with
respect to electricity, right? This was more relative. This was relative to the water.
The electrical engineer was a rep of Con Ed. That's true.
Right.
Which is why, by the way, Con Ed both is liable under the notice theory because they had
But what specifically did Con Edison do to direct plaintiff's work?
Well, the case that they rely upon, Your Honor, is Mitchell to say that he didn't have means and methods.
Not the case. What does the evidence show as to what Con Ed did?
They controlled whether or not it was energized. They dictated what PPE the waterworks employees had to have. They dictated where they dug, what means they used to dig, and when they dug. So I don't see a more clear means and methods case here. The fact that it wasn't communicated directly to the laborer, but just to his foreman, there's no law to say that that's not sufficient means and methods case.
Did they also make announced and unannounced inspections?
They did. In fact, they asked Waterworks to supply them with shanties, facilities, so they could have people on site 24/7, surprise inspections, and biweekly inspections. So they had 2 to 4 people on site at any given time. In addition to the fact, and Your Honor referenced this earlier, in Elise, which talks about the plate, the 1959 case, that case they had an iron plate covering it. By contrast, in Adonisio, this court found that that was a dangerous condition for which Con Ed was liable under 200 because it was only wrapped in concrete. It did not have a steel plate. Here, at best, giving them the favorable inference, even though they were the move-in, this live wire holding thousands of watts was just wrapped in clay or some terracotta. So that's why when it was pierced or shorted out, whatever, we don't know because there's inconsistencies in the testimony, it caused this explosion.
Thank you.
I just want to go back to the question by Justice Pittsburgh about the definition of operations and how that would actually be interpreted. And I'd like to go to the New York Public Service Law that we discuss on page 16 of our moving brief that talks about the jurisdiction of the PSC. And under New York Public Service Law 116b6, the PSC has the authority to inspect, have employees there, and provide regulations, not for just providing electricity, but for any excavation or demolition methods used by any person within 15 feet of any direction of an underground pipeline used for conveying natural gas, telephone, electric, steam, or water facility. This was a PSC-controlled operation. PSC was there. Con Edison had to follow PSC regulations, not the industrial code. Waterworks, its contractor, had to follow PSC regulations, not the industrial code on this section. So for the plaintiff to say the city should be liable under section 113b4 for Con Ed not de-energizing its circuits, the PSC doesn't require it. Con Ed doesn't have to follow the industrial code. Waterworks doesn't have to follow the industrial code. How can a 241.6 premises owner be liable for an industrial code violation that everybody in the chain of construction command didn't have to follow? That is entirely inconsistent with the statute, the way the agency interprets its own authority, and the application of 241.6 under risotto, which makes the owner vicariously liable for the subcontractor's violations. If there's no violations, it cannot be liable for it. Unless the court has any other questions, I will rest on my brief on the other points.
Thank you. Thank you both. Lou versus Saffron.
Is it Lou?
I'm
Lou?
sorry? Lou. You just like move over to the other chair?
Yeah. So the lower court erred in lieu was specifically with respect to 241 by applying McCann in saying that the ramp was.
I'm sorry, client, you're representing.
I apologize. I'm the
Counsel,
plaintiff
who are you
appellant.
representing now?
The plaintiff appellant. Okay, so when the court dismissed 240 sub 1 on this case, they were relying on a case that was handed down before Runner. And it seems to me at its simplest form that this is really a Runner case. And this is a case with 25-foot ramp. It was being used as a device, and it exposed the plaintiff, whether it was a device or a passageway or not, to a 25-foot elevation differential. It could have been equipped very reasonably and very easily with railings around it to prevent workers from falling down it. It could have had curbs to stop his free fall descent when he slid down the ramp very easily.
Well, he didn't fall down. He walked. He attempted to walk down this ramp, right? So the railings maybe at the top, not.
I would disagree with the framing of your question only in as much as he attempted to walk down a set of stairs. And when he stepped, there was a ramp in its place. So it was at one point single-sided, and later we don't know based on the testimony who and when.
Did he think that there was a staircase there?
That's correct. That's his testimony. When he went to take a step, he thought there was a staircase there.
So the ramp, who constructed that?
Well, that also is really unclear. It's asserted that the plaintiff's company had installed it. That's based on hearsay. It's based on really inconclusive change orders that are dated after the fact. But I'm going to point out, in any event, whether it was his company or not, if he knew that the ramp was there, which is not supported, that would just be comparative negligence. At the end of the day, this is a 25-foot edge from a first floor to a basement. And all Runner has said is that if it's reasonable to implement safety devices that are enumerated under the statute, the defendants are liable.
So, counsel, in Royland, this court determined that a ramp could be considered a tool, right, as opposed to a passageway, and the most significant factor was the height differential. So here, as you were saying, the height differential is one of like a 25 to a 30-foot.
It's very, very significant. In fact, the cases that the respondents rely upon, Jackson, Sowachin, Donahue, are all dismissing ramp as passageway cases based on de minimis differentials between a foot, foot and a half, 2 feet, also extended over the lateral distance, right? So the incline is not that much. Here, it's a very steep incline. The record has photographs of this ramp, slick with plywood. So it is an edge that should have been protected with railings, and it could have been curbed so he didn't free fall all the way down, causing his.
There's a deposition testimony that there had been tape put across the front opening of the ramp.
Except the tape had been removed.
It was removed.
Yeah, and when they did the inspection, McCann, I believe is his name, testified that the tape was not there immediately after the accident. Also, I just want to add, because I see my time is running out, with respect to 200, the court below applied really a means and methods analysis to the owners here. That was error. It's our position that this very clearly constituted a dangerous condition on the site. They had notice of it. It was discussed at meetings amongst the agents, the general contractors, the supers. They even admitted in their deposition that they thought it was dangerous. It was never corrected, at least with respect to the plaintiff's accident in time.
Are you saying it's both means and methods and defective construction?
No, I'm saying by applying a means and methods theory to the owners, the court erred. For respect to the owners, this was a dangerous condition on the site, and they had notice of it, which is why there's no issue of fact. I'm entitled to summary judgment on Labor Law 200 against the owners, as well as White Star. And if there's no further questions, I can rest on my papers.
Thank you.
Good afternoon. May it please the court. Kyle Silverstein of Cascone and Clubfell on behalf of White Star Consulting and Contracting. This court should affirm the motion court's decision dismissing plaintiff's Labor Law 241 claim because the ramp was not acting as a functional equivalent to a ladder or a scaffold. It was merely to transport materials, and plaintiff was not transporting materials, so it was not through an insufficient safety device, and there was no gravity upon an object that caused the plaintiff to fall. Rather, the plaintiff just fell.
Well, there's gravity on the plaintiff, isn't there?
Yeah, but the gravity on the plaintiff is the same as saying...
Doesn't count?
It counts, but the plaintiff fell without any reason, without any gravity-related harm expected. This was not a case where the plaintiff was working.
Ramp over a steep staircase.
The ramp, I'm sorry, I didn't hear you.
The ramp was steep, wasn't it?
The ramp was as steep as the staircase would allow, and I think actually...
well, a ramp is different from a staircase. I mean, stairs, by definition, you can go one at a time, right?
Of course.
A ramp, there's nothing stopping you. He went all the way.
Well, in this case, plaintiff testified that there were side rails there. So
he held on, and with his first step, his right foot slid.
Yeah.
And I believe you emphasized that he had rubber-soled sneakers. I don't know how that's dispositive, because rubber-soled sneakers might stick better than other types of shoes in giving you traction. But he slid that whole length through, and you're saying the fact that he didn't have tools in his hands made a difference?
I think it does make a difference, as counsel has been pointing to the Runner case. In Runner, the ramp that was used was to lug an 800-pound wheel of wire, and by an inadequate safety device, I believe in Runner, they were using two different people to act as
I have a
counterweight.
question about that, because you say in your papers that the ramp was for equipment only. How was the equipment supposed to get down the ramp without someone being there holding it or doing something with it? I mean, you just put the equipment on the ramp and magically it goes down?
Well, in that case, I would assume that Labor Law 241 would apply, but as Cool Breeze, who was the one using the ramp to move the equipment down the ramp, they appropriately called for a rigging company to come in and to move the equipment down the ramp. No one was hurt by the ramp doing anything other than that. In fact,
So when you say that the ramp was for equipment only, you mean in addition to other apparatus in order to get the equipment down the ramp?
Yeah, so it was, I believe, an HVAC unit that couldn't fit in an elevator, and so they had to cut it up into
But
six pieces.
there's no testimony that I found anyway in the record as to how equipment could be safely moved. I tried. I looked at the photographs. I saw the center rail, the center handrail. I read the testimony that the ramp covered half of the stairways at one point, and then there was a complaint, and then the other half appeared. And no matter how I played with the pictures and the testimony, I had the same concern as my colleague. How was that ramp safe for people to walk down or for equipment to go down? There's no testimony that there were pulleys or ropes or anything, and the plaintiff's safety manager, site safety manager, who provided, I don't know if it was testimony or an affirmation. She said there was all this, the ramp should have been barricaded in some way with wood, iron, ropes, or signage so that nobody other than workers actually delivering materials would be using it. That wasn't there. How are you outside the parameters of the labor law? I don't see it.
I would argue that because the Labor Law 240 specifically is about gravity-related issues and working at an elevated height
How is a
differential.
ramp not, how are we not talking about gravity and elevations when we're talking about 25 to 30 feet?
I think we are talking about the ramp as can be used as a tool and it can be subject to Labor Law 241, but the argument here specifically is that plaintiff wasn't doing anything related to a height differential of working. I know in his reply brief, he mentions a case lateri or a lattery where the plaintiff walked up a ramp, was doing something.
Conducted regular inspections, right?
He was working on an escalator underneath the air tram.
I beg your
and
pardon?
He was working under, it was a crawl space ramp. He was working under an escalator. So he was up there fixing something. He then was going down, he slipped on the ramp, and he banged his shoulder into an overhead
I'm
pipe.
talking about the plaintiff here.
In this case, the plaintiff was walking down, was trying to walk down a staircase and there was a ramp there. But that's not the same because the elevated, there's no evidence or anything to the contrary that says that he was exposed to a height differential and a safety device would be preventing him. He could have fallen anyway. The railings were there in the first place. So as a secondary argument, if you would assume that the ramp was being used like a scaffold or a ladder or another safety device, there's no testimony.
So are you arguing against yourself and saying that the handrail was defective, that it wasn't sufficient to provide protection to anybody walking down?
I think that's not the argument in this case at all. The argument here I'm just saying is that the ramp here, we're focusing on the height differential and saying that he fell because there was a height differential. Automatically, that means he's under Labor Law 240 sub 1. That's not what the Court of Appeals has said. That's not what this court has said. That's not what any court has said. This court, as well as every other court, has said that the safety device has to come into play. There has to be a reason why he fell. And if he's working at an elevated differential, and perhaps if he were working on the ramp and the railing did break, that would be a different concept. That would be a different case because the railing would have broken. That would have been an inadequate safety device.
Thank you.
Please affirm the motion court's decision. Thank you.
Very briefly, just to cap on Your Honor's question with respect to the expert affidavit that was submitted below by the plaintiff, we submitted cases in our brief that just ropes alone along a ramp can be a device under 240. With respect to the claim that the plaintiff was not within the purview of 240 sub 1 because he was conducting or on his way to conduct an inspection, it's Pratt's. It's a Court of Appeals. There's more cases in the brief. It just escapes me right now, but it's about the fact that he's walking around. There's a First Department case from 2015 or so. They're walking in to check in, and they fall off of an elevation, and that triggered 240 because it did not have railings. The fact remains this was an unsafe ramp. It exposed the plaintiff to a height elevation. He free fell, and he broke his leg. 240 sub 1 was violated here, and the defendants are liable. Thank you.
Thank you. Thank you both. People v. Chase Leggett.
Good afternoon. Karen Brill with the Office of the Appellate Defender on behalf of Chase Leggett. Chase was 18, 2 months removed from the death of his 9-year-old baby brother, Chaz, and living away from his mother at the time of his first and only criminal mistake.
Counsel, assuming for the sake of the argument that the waiver was proper and valid, would we still be able then to consider what you're asking, that we adjudicate him a youthful offender?
If the waiver were valid, no. But you would still be able to consider all alternative asks that you remand for a proper youthful offender proceeding pursuant to this court's holding in Ochoa. But we do not believe the waiver was valid. Chase was 18 at the time. He had a 10th grade education, and he had no prior experience with the criminal legal system, and the court explained the waiver to him in a single sentence. That is not sufficient to suggest that he understood both what the right to appeal was and what it
Does
meant
the
to-
written waiver in any way cure that?
It does not. What Thomas makes clear is that you have to consider the totality of the circumstances, and that includes a defendant's age and experience.
Okay, so the court explained to him what it meant to plead guilty, that he would forfeit his trial rights. We went through a separate discussion of the defendant's appellate rights, explained about the right to appeal. Defendant was asked whether he wanted to waive his right, et cetera. So I don't see how this waiver was invalid.
The court never actually told Chase what his appellate rights were, and never suggested to him that any appellate rights would survive a waiver, where Chase had no prior experience at all with the criminal.
I recognize he had no prior experience, and you say that that the court never explained the right to appeal. But my understanding is that this court nor the Court of Appeals has ever stated that there's a specific colloquy that has to be stated to a defendant. So what was not stated to the defendant concerning his appellate rights?
Right. So what this court has stated is that the nature of the right has to be explained. And again, the nature of what the appellate right was never explained. And especially what was never explained is the rights implicated here, that he had the right to appeal whether he was adjudicated a youthful offender, and to ask this court to, in its interest of justice.
But those rights were explained in the written waiver, correct? Do you agree with that?
The right to review a sentence was not to change it.
The written waiver stated that the defendant was waiving his right to, quote, ask the appellate division to review the terms of the plea and to reduce the sentence.
Yes, exactly. And while you and I, while we understand that that encompasses the youthful offender adjudication, someone in Chase's position who's not familiar with all the legal term of arts.
Was he represented by counsel?
He was represented by counsel.
Was counsel present at this time?
Yes, but the court had an independent obligation to explain the waiver. But I do want to just touch on the non-waivable issue here, which is that the court misapprehended Chase's eligibility for youthful offender treatment.
But at the end, the court became aware of the fact that he was eligible.
The court never said that it considered him presumptively eligible. At plea, the court twice called Chase's offense an armed felony. It was not. Probation marked Chase's recommendation for youthful offender treatment as not applicable. It was applicable. And at sentencing, the court never said that it presumptively understood Chase to be presumptively eligible for youthful offender treatment, which he was. What this court held in Ochoa is that a person is entitled to a consideration of their application for youthful offender status without any misapprehension operating on the court about their eligibility. The court was clearly operating under a misapprehension here because it considered Chase's offense to be an armed felony, which is a category of offense that the legislature considers to be inherently more severe and adult than Chase's actual offense was.
I thought ultimately the court held that YO would not be appropriate under the serious circumstances of the case.
Well, the court held that while believing that the case was about an armed felony. So it's not that easily separable, and that's the same holding this.
But at sentencing, didn't both the people and defense counsel argue on whether or not the defendant should be accorded YO treatment?
Yes, Your Honor, but they would be arguing that even if he was presumptively ineligible because he could become eligible if he proved statutory mitigating factors. And in fact, what defense counsel argued is that there were mitigating factors, suggesting that defense counsel shared the same misapprehension.
So where did the court, I'm looking through the plea allocution here and sentencing, where does the court say that the defendant was presumptively not eligible for YO treatment?
It does not, but the court does not say that he is presumptively eligible, and that's after the court has twice said that he was convicted of an armed felony, which is a presumptively ineligible offense. And I'd also just briefly add, the court's language is that this was not the offense of a youth. That's what he says when he denies it. The legislature would agree in the case of an armed felony, presumptively, it's not the offense of a youth. For what Chase actually did, it is presumptively eligible for youthful offender treatment.
Counsel, the court here basically said the fact that in this instance, the defendant in possession of a weapon shot the mother of their child is monstrous to me, to the fact that he should not be treated as a youthful offender.
Yes,
It seems that the court based its analysis on denying youthful offender on the facts of the case, that it made the appropriate and required analysis.
even if that was the majority of why it made the decision it made, what Ochoa holds is that the misapprehension cannot be operating to the court. I want to be clear, Ochoa never holds that the error, that was required a new determination because the error was harmful. Ochoa never holds that in that case the court would have given youthful offender adjudication but for the misapprehension. But
see, I don't see that as a misapprehension. I see that as a statement as to why, under the circumstances of a particular case, the court is not affording the defendant youthful offender status.
Again, the misapprehension is that.
But you have time on rebuttal.
Thank you.
Good afternoon, and may it please the court. Molly Morgan on behalf of respondent. The court correctly considered and then denied defendant's request for youthful.
Also, aren't the facts in this case something that makes the granting of youthful offender to this particular defendant the very essence of why we have youthful offender?
Well, Your Honor, I think the court providently exercised its discretion, and it is an abuse of discretion standard in denying that application, especially in light of the serious nature of defendant's crimes. I think his actions need to be viewed in the aggregate, not just the offensive.
Well, if you view them in the aggregate, what do we have? We have, I think, an accidental shooting, right? There is no indication or no allegation that he shot his pregnant girlfriend intentionally, right? Then we have he absconded, he left, he ran away, which is, I'm not justifying it, but he's 18, right? What else do you have?
Your Honor, I think especially his actions in the wake of the claimed accidental shooting, I think they speak volumes to.
Counsel, is there any reason why the focus should be on the accidental nature of the shooting? There was nothing accidental about his possession of a loaded weapon. He obviously made a determination at some point before this to acquire a weapon. It was a loaded weapon, there's no question about it, because his girlfriend is shot. So what difference does it make whether the shooting is accidental? His participation in this crime is unequivocally intentional. He went out and decided as an 18-year-old to acquire a loaded weapon.
Precisely, Your Honor.
So is it your position in all criminal possession cases that what youthful offender does not apply? Because that's not the law.
No, not at all. The court, again, correctly exercises discretion in determining that in this particular case, youthful offender treatment wasn't appropriate.
And that's what I'm asking you. What about this case makes it inappropriate? If we agree on the concept that on the criminal possession case, youthful offender can be appropriate, I want you to tell me what in this case makes it inappropriate.
Your Honor, as our brief lays out, again, and as I was mentioning earlier, his actions in the wake of the offense speak volumes. I don't think his flight.
Be specific. You mean about him leaving to Connecticut?
I don't think that can be correctly characterized as hasty or thoughtless. It was quite calculated. He immediately fled. He disposed of his phone to avoid apprehension, and then he was in Connecticut for nearly 2 months until he was arrested. He's now trying to paint his actions as immediate contrition, and that's just not faithful to the record.
Is the issue for us whether YO is appropriate here, or whether there is an abuse of discretion in Supreme Court denying YO treatment?
Exactly, Your Honor. The question here is whether the Supreme Court abused its discretion, and clearly, as the court explained on the record, the youthful offender adjudication wasn't appropriate given all the circumstances in the case.
Well, was there any misapprehension by the court as to whether it could, in fact, confer youthful offender status?
No, I don't think the record shows that the court was operating under any kind of misapprehension. The court stated at the plea that it would consider that request, and at sentencing, the court statement just made abundantly clear that upon all the facts in the case, youthful offender was inappropriate. Again, the court cited the unspeakable nature of defendant's conduct, how he illegally possessed a weapon and then handled that weapon in an extraordinarily dangerous manner. And, with respect to Ochoa, I think that case is an opposite here, as there's no concrete indication that the court misunderstood that defendant was eligible. And in fact, I would also note that the people at the outset of the sentencing proceeding opposed youthful offender treatment and noted that the top count in the indictment was an armed felony. So that makes clear from the outset that the offense that defendant pled guilty to was not an armed felony. And then moreover, defense counsel went on to argue all of the reasons why, in support of youthful offender treatment, but there was never a mention of presumptive ineligibility at sentencing. And, I think my adversary's attempt to cast defense counsel's statements as misapprehension on counsel's part is misguided, because the mitigating factors in CPL 7-2010 subsection 3 go directly to the manner in which the crime was committed, and defense counsel's application went beyond that and discussed defendant's personal circumstances in his life.
Counsel, can you speak as to the waiver of right to of appeal? Because it seems to me, and your adversary has conceded, that if the waiver is valid, that forecloses anything that we could do with regards to the youthful offender. It seems to me that the allocution here was not robust.
It might have not been robust, but as Your Honor pointed out, there's no specific colloquy that's required. If I might just wrap up and submit that, the trial court separated the trial rights that were being waived by virtue of this plea from the appellate rights, and we also have a very clear written waiver of appeal that sets forth not only what appellate rights would be retained, but what specifically he was relinquishing. He also benefited from consultation with counsel, and he confirmed that he had consulted with counsel to his satisfaction. So again, the waiver of appeal is valid and appropriate and forecloses defendant's claims, and we ask that you affirm.
Thank you.
To briefly touch on the
Counsel, can you give me an idea of an 18-year-old who acquires a gun, either the gun was loaded or he loads it himself. He then displays that gun to his girlfriend and shoots his girlfriend, and then doesn't own up to the responsibility of that, but then flees the jurisdiction. If that sort of a defendant gets youthful offender treatment, could you give me an idea of what sort of a defendant wouldn't get youthful offender treatment?
Someone who, unlike Chase, at the moment of criminal intervention happening, did not change his entire outlook. There are 2 points of time, right? There's the time before Chase had ever had any contact with the criminal legal system in which he made poor decisions characteristic of an 18-year-old. And then he gets arrested, within a month decides to plead guilty, apologizes, earns Ms. Felix's forgiveness, develops concrete plans to get his GED and to take vocational courses in prison, and has now served 2 years.
Yeah, but doesn't he, when he had to go back to school, instead of going back to live with his mother, he fled to his father instead of going back to school?
Again, that would have been better, but we're again talking about Chase before he had had the benefit of the intervention of the criminal legal system.
But
At this
counsel,
point,
I think we're talking about 2 different things now, because now you're asking, are you asking us to say that the trial court should have made the youthful offender decision at that time, or you're asking us to say that the waiver is invalid and now say that he should have youthful offender? What are you asking?
so even by the point at sentencing, Chase had already come a long way in terms of taking responsibility and developing plans for his future. What that shows is that already, and at this point, Chase has served 2 years, there's no more peniological purpose to having him have
But counsel,
lifelong stigma.
the problem is that we are constrained, right? The only way we can confer youthful offender status is to find, one, that the waiver was invalid, which arguably it was not invalid, or 2, to find that there was an abuse of discretion by the trial judge in not affording the defendant youthful offender status. And I don't know that there's anything in the record that would show that it was an abuse of discretion. Your argument was that the trial judge misapprehended whether he could in fact confer youthful offender status, but it doesn't seem, based upon his statements, that that was the case. So, I mean, it becomes difficult for us to say now, yes, youthful offender status should be conferred, and we're going to do so. We're not the sentencing court with the appellate court.
So had this gone forward as though the court properly understood Chase's eligibility, there would have been a recommendation in the probation report, in the pre-sentence investigation report, of whether Chase should get youthful offender status. That is a classic crucial factor for whether YO is appropriate, is whether or not probation has recommended it.
So the pre-sentence report doesn't state whether the defendant is WIO eligible or
It
not?
does not. It marks it as not applicable, and it was applicable. So that's the evidence right there that the court's misapprehension tainted the.
Well, that's the probation, the Department of Probation's misapprehension. It's not the court's misapprehension. But again, we'll take another look at the briefs and the record. Thank you both.
Thank you.
Philadelphia Indemnity Insurance Company.
May it please the court for respondent, Philadelphia Indemnity. Your Honor, I'll be brief. We just want to point out in the reply papers by the appellant, they were asking the court to consider a lesser sanction of an inference to be drawn at trial. We just want to remind the court that this is a review of a 3211 CPLR motion to dismiss. The court below properly ruled that my case should be able to proceed against the defendant, and that the defendant, Addison, did not meet its burden of showing it was irreparably harmed by the alleged spoliation of the water heater. So the court need not reach the issue as to whether there should be any kind of inference drawn at the time of trial. The court below left open the door for Addison to make a motion at a later time. If the court does reach the issue as to whether a lesser sanction should be considered, we just want to point the court to its ruling earlier this year in Harry Winston. That's a 2023 case in which the court said there's 3 elements that have to be met in order for there to be a sanctions for spoliation. One, that the non-moving party had an obligation to preserve the item, which clearly my client had the obligation to preserve the water heater. Number 2, that the item was destroyed with a culpable state of mind. Here, the water heater was not destroyed, it was preserved, and certainly there's been no showing of any culpable state of mind to alter it. And that number 3, the destroyed item was relevant to the party's claim or defense. And here, I also want to call the court's attention to your ruling on July 20th of this year in Scalar versus 650 Park Avenue. There, the court found that videotape which had been destroyed was not relevant because the defendant conceded that they had destroyed contents of the plaintiff's locker. In this case, plaintiff is arguing that the water heater should have been properly piped and it should have had an alarm system. The allegations of spoliation in this case are not relevant to the issues raised by the plaintiff. Unless there's any other questions, we'll rest on our papers.
Thank you. Thank you very much.
Thank you, Judge.
Enjoy the trip back to Albany. Ringel versus Ringel.
May it please the court, Ephraim Schwalb on behalf of the plaintiff appellant. The trial court, we believe, made a mistake in dismissing plaintiff's fraudulent transfer claims based on CPLR 3211 AD, claim splitting, and the settlement agreement. It's important to understand the facts over here in the sense of what was the prior action and what was the action that we brought here. In the prior action in New Jersey, brought in two actions in 2015 and 2016. Chana Ringel, the plaintiff, was suing Benjamin Ringel for his conduct in connection with the company that they jointly owned through 2 other entities, BR Lakewood and CR Lakewood. They owned this company, BCR Lakewood Holdings. And
has the arbitration taken place?
It has taken place. In the papers, we noted that Chana Ringel got a judgment against Benjamin Ringel for $1.8 million. So that's a public document in New Jersey that the court can take judicial notice of. So the case was going on for 5 years. Benjamin Ringel, the allegation was that he was looting two companies, BCR Lakewood Holdings, BCR Oak Ridge, and Chana Ringel moved to remove him from being the manager, co-manager of the companies, and for monetary damages. That case, 5 years later, settled in New Jersey court, and there were a whole slew of things that had to occur. A property had to be sold.
Why shouldn't, for the points that you're raising on appeal, why shouldn't that issue go back to Supreme Court to see to what extent the arbitration may have resolved those issues? And if they haven't and they weren't dealt with in the arbitration, I understand that the arbitrator said that these things don't belong in front of the arbitrator, that Supreme Court reconsider its position about the claims that you're making.
Well, the answer to that is, I believe that there are, I mean, obviously we would like reversal. So it's a good thing to be reversed and for the Supreme Court to reconsider. But when we mentioned certain items to the Supreme Court judge, she was not interested in re-arguing these issues. And these issues really are not relevant to what happened in the arbitration. The issue of the settlement agreement, which I think is the most important argument that they make, because this is not a 3211A4 case. It's not the same parties. It's not the same causes of action. So 3211A4.
The fraudulent conveyance? You're talking about the
fraudulent conveyance that we.
So paragraph 5 of the settlement agreement does not cover the fraud.
Right, so that's the settlement agreement. So paragraph 5 for sure is not covered by it, because the remaining claims had to do with BCR Lakewood Holdings and BCR Oak Ridge. They had nothing to do with a fraudulent transfer of BR Lakewood LLC. The one argument that they made.
I mean, there's also obviously the point that you raised that Supreme Court relies on 3211A4, which wasn't even raised by the other side.
Sure, and nor was claim splitting, and that was unfair to us. Right. We didn't have a chance to make these arguments, but she wouldn't hear of the re-argument. She said, take it to the First Department and find out what the court has to think. And that's in the record as well. But the main thing I wanted to point out is there's one provision. I think their best argument is paragraph 7 of the settlement agreement, which says the court shall maintain jurisdiction over the parties to enforce the terms of the settlement agreement.
Not to address new claims. But not to address new claims.
Well, not to address enforcement of a judgment.
Right.
Enforcing the settlement agreement is the sale of Pinewood, the splitting of the properties, everything else.
So that's your argument that paragraph 7 does not apply.
Correct, and I think that's their
it doesn't
best
apply
argument.
to the claims that you're making that were dismissed.
Right.
Right, the fraudulent transfer claims that apply to things in the settlement agreement. This fraudulent transfer claim has nothing to do with the settlement agreement. We have a lot of things going on in New Jersey, but we have to be able to pursue our claims, the fraudulent transfer claims, wherever we have to pursue them. If he has property in California, I have to be able to pursue them in California. If he has property in New Jersey, it's fine. But over here, it's New York property, New York trust. It's the ownership of this BR Lakewood company. So for those reasons, we believe the decision of the trial court should be reversed.
Thank you.
Thank you.
People v. George Harris.
May it please the court, my name is Paul Wiener, appearing for appellant George Harris. The court found after a competency hearing held prior to trial that the complainant could not give sworn testimony because she did not understand the meaning and the significance of an oath. The complainant had a long-standing, substantial, readily apparent mental disability. She was on SSI. She had a designated payee because she could not handle her own finances. She functioned at about a second grade level. She attended a special school. The prosecutor was aware of all this, but still allowed the complainant to testify as a sworn witness.
Well, the prosecutor was, my reading of the record is that the prosecutor, the assistant, was not aware of this at the time that the case was presented to the grand jury.
No, Your Honor. The prosecutor admitted that she was aware of this. She knew that she was on SSI.
I thought she said she had spoken to the complainant 2 or 3 times, and it was not clear to her or apparent to her that the complainant had any issues prior to the grand jury presentation.
No, Your Honor. She acknowledged that she knew that the complainant she knew that she was on SSI. She knew that she was that there was a payee, that because she could not handle her own.
In your 19050 motion, because presumably the husband would also be aware of all of these things at that time, was that part of the motion to dismiss the indictment?
You mean
was that raised in the issue?
In the omnibus motion.
Yeah. 19050 was in the 19050 motion for the sufficiency of the grand jury.
Right. Counsel did not even know. Counsel didn't have the grand jury minutes at that point.
Well, why would he need them? He had the husband. The husband could have told him all of this.
Counsel didn't even know that the complainant was testifying in the grand jury.
Who else was going to testify?
Well, they could have.
Well, I mean, but even so,
witnesses. I mean, she didn't. She didn't have that information. As soon as she got the grand jury minutes, look, I mean, the judge acknowledged, the judge said that it was readily apparent, and immediately apparent, that the complainant had a substantial cognitive impairment. This was a long-standing thing, and we are not saying, all we're saying is that the prosecutor, I mean, she was clearly aware of this, she acknowledged that she was aware of this, and she didn't take simple steps. She didn't voir dire the complainant about her competency to take an oath. She could have done that formally or informally. She could have gone to the grand jury judge.
Is that remedied by all the questioning by the judge and by all the questioning that took place of the complainant? Because I will tell you that the judge's assessment of credibility is very carefully explained, and the explanations are nuanced. It seems like there was a thorough investigation of the complainant's ability to tell right from wrong, a lie from the truth, even though she couldn't express such in overarching terms.
You're right. The judge, there was a competency hearing held before trial. The problem was there was nothing held at the grand jury level.
So we're back to that now. So the prosecutor stated that he or she had met with the complainant 3 times prior to the grand jury proceedings and determined that while the complainant's observed mental disability, that the complainant's observed mental disability did not materially impair her ability to relate the facts of the incident and or to tell the truth. Then we're back to what my colleague asked you in terms of the grand jury, the 190-50 motion. The defense never moved to dismiss the indictment based upon the insufficiency of testimony presented in the grand jury, and you could have said based upon the insufficiency of the testimony presented by the complainant.
But again, the lawyer did not have the minutes, and I'll point you to the
Okay, so now we move to trial. So now we're at trial, and there's a determination made by the judge after a long colloquy and examination of the witness that she is able to appreciate or understand what occurred and to testify to understand and testify as to what occurred, and also to understand the nature of right from wrong or lie from non-lie.
No, the judge found that her story was coherent enough so that she could testify as an unsworn witness, and we're not disputing that. The question is, she wasn't allowed to testify as a sworn witness, and that's critically important because in the grand jury, there was no corroborating evidence, but if she had testified as an unsworn witness, it would have been improper. Because she testified as a sworn witness, the prosecutor could avoid presenting any kind of corroborating evidence. You know, I just want to say one more thing. It's disturbing because if you read the trial testimony, it's readily apparent that this witness has trouble distinguishing, you know, from what is true and what is not true. She says things that are completely inconsistent on their face. She says, I was hit once, and that's true. I was hit more than once, and that's also true. I was hit, my face hurt, and that was true. My face did not hurt, and that was true. I went to the police, and that was true. I did not go to the police, and that was also true. Again, the prosecutor was aware of her, that she was on SSI, that she could not handle her own finances. The judge said that it was readily apparent that she
Being on SSI and not being able to handle your finances does not really go to whether or not you know whether you were hit or not. I'm not, but anyhow, you have time on rebuttal.
All right, thank you, Your Honor.
May it please the court, Andrew Seawald for the people. Good afternoon, Your Honors. In this case, there was no prosecutorial misconduct in the grand jury by the prosecutor by permitting this 44-year-old complainant to testify under oath. I first want to say the posture by which this argument was presented below is a little bit unusual, and I would suggest to the court, as I argue in my papers, that the prosecutorial misconduct argument is unpreserved. that the argument the defense was making below, even...
The omnibus motion attacking the sufficiency of the evidence, right?
That's right. So
when for the first time does the issue of incompetency of the witness come to the fore?
it comes at the outset of the trial when the prosecutor alerted the judge that that she wanted latitude in questioning this witness because the witness had some mental issues. And at that point, it's interesting.
So normally what a witness does in the grand jury is not something you could particularly hold against the defendant for not raising because the defendant doesn't know what the witness says. But your answer to that here is that it's his spouse. So if there were issues relating to a competency, he was from the get-go aware of it.
That's true, and there were discussions between the prosecutor and the defense attorney at the outset of the case. There were some plea negotiations before the case was presented to the grand jury, and so it could have buld mentioned at that point.
Did the defendant know that his spouse had testified before the grand jury?
Not until the minutes were turned over, but I would note that in this case, as is common practice, the defense made all sorts of hypothetical arguments about why the indictment should be dismissed, like the grand jury wasn't composed properly or was different things like that.
So on the 19050, in terms of the sufficiency of the grand jury minutes, there was a judge who reviewed those grand jury minutes.
That's correct.
And reviewed the evidence and the testimony presented to the grand jury.
That's correct.
And made a determination that it was sufficient.
Yes, that's correct.
Okay, so now we get to the trial, and the minutes are turned over to the defendant, and the defendant now reads the grand jury minutes and sees that his wife testified before the grand jury.
Yeah, and I would also say, just to go back to how this came up, and this answers Your Honor's question, when the prosecutor said, I'd like some latitude in questioning this witness, the defense attorney's reaction was, well, I've read the grand jury minutes, and there didn't seem to be any need for latitude, meaning that the witness was perfectly responsive to the prosecutor's questions in the grand jury. And that comes back to the question of whether there was something that would have put the prosecutor on notice that the presumption that applies to every witness over the age of 9, a presumption of competency, should not have applied to this witness, simply because she had different or lower mental capacity than maybe the ordinary witness would have. And in this...
Also, I just want to clarify something. It seems to me that the defendant is not attacking the sufficiency of the evidence in the grand jury based on her alleged incompetence, more so than they're saying that the fact that she was permitted to testify on the oath was an assault on the integrity of the grand jury process.
Well, I suppose that's what they're arguing on appeal. They never really made that argument below. And in fact, the trial judge, Justice Hayes, he repeatedly asked the defense, exactly what are you asking me? What argument are you making?
Well, in that regard, it would have gone a long way in making that argument if the defendant had said, she's my spouse, I know that she has these issues, and alerted the court, but that wasn't done.
That's right. That was not done prior to the grand jury. That certainly wasn't done, and it was not done even
on the motion to dismiss or
motion to dismiss.
So what would the remedy be at that point in time? A representation or dismissal of the indictment?
Well, only if if there were prosecutorial misconduct, I think
that would be dismissal.
The representation would be dismissal, I think, with leave to represent.
Right. So that would be okay.
But if the argument was a sufficiency argument, sufficiency of the grand jury minutes, then that goes away after once the trial's happened. Right. And so that's why on appeal, it looks like the defense is trying to recast the argument they made below as a prosecutorial misconduct argument, which was not an argument they made at that
Right.
time.
Okay, so now she testifies at trial, and she testifies, but she doesn't testify as a sworn witness.
That's right. She gave unsworn testimony at trial, but it was corroborated, and they're not arguing that the evidence was insufficient to prove the contempt charge of which he was convicted. But for all of these reasons that I think I've now discussed, the presumption that applies to every witness who's 9 years old or older applied to this witness. The record shows that the prosecutor had discussed the oath with the witness prior to having her testify in the grand jury, that she, and then she testified responsively. There was nothing that put the prosecutor on notice that she needed to conduct the sort of voir dire that would apply to a witness who's presumed incompetent, like a child witness, and therefore there was no prosecutorial misconduct in allowing this witness to testify under oath in the grand jury. And for all these reasons, I ask the court to affirm.
Thank you.
Thank you.
Just briefly, a couple things. First of all, there's no question, it's on page 10 of my brief, I cited a page number. There's no question that the prosecutor admitted that she knew at the time of the grand jury that the complainant had this mental disability. That's in the record. There's no question about that.
But a mental disability does not mean that you're unable to testify under oath and testify truthfully under oath.
Not necessarily, but she also knew about that she, again, had a payee because she couldn't handle her own finances. But the point is, she should have questioned her. It was her obligation to voir dire her, whether formally or informally, or at least go to the grand jury judge. I mean, it's not really, we're not, she didn't, and you know, we're not really asking that much be done, but it should have been done. And it's really disturbing in this case because we know that after this competency hearing, 4 months later, nothing changed. It's not like she had an accident or something between those 4 months and her cognitive abilities changed. Nothing changed, and yet she was found to be
Okay,
not
so
competent.
what do you do now at trial? Was there any motion to the trial judge in terms of the sufficiency of the grand jury presentation?
I'm sorry, Your Honor.
Is there any motion to the trial judge in terms of sufficiency of the presentation? Is there any request for any specific remedy, that there be a representation or anything of that nature?
The motion was made for a mistrial based on what had happened in the grand jury, and a
mistrial.
There was a mistrial motion. I believe it was. I don't know if it was. I may have been wrong about that.
There's no trial, so how do you get a mistrial?
Okay. Well, maybe I'm sorry. She made a motion and said that the indictment should be dismissed because it was improper. I also want to just quickly say there's no question that counsel was arguing that the integrity of the grand jury was impaired. She was arguing that the prosecutor knew about the complainant's condition. And she explained why, because the prosecutor had handed over documents to her that indicated that she knew at the time of the grand jury about her condition. She also outlined the steps.
When you say condition, again, are you referring to some mental illness or defect? Because that doesn't necessarily equate to being incompetent to testify. Those are two very different things. Are you suggesting that whenever the prosecutor has a witness that there's any indication that they're suffering from some mental illness or some mental defect, that they have an obligation to voir dire them to see if they're competent?
I think that the evidence in this case is that this witness was functioning at about a second grade level. The judge said it was readily apparent, and I do think under these circumstances that there was an obligation. You know, she's acting both as the prosecutor and the judge to at least do what the trial judge did, which is to ask some questions and about her ability to understand an oath. And the prosecutor did not do that here. And thank you very much.
Thank you. Thank you both. Excuse me. Deco Towers versus Fish.
Good afternoon, Your Honors. Joseph Haspel for the appellant Samuel Fish. Your Honor, this case presents a settlement agreement which we maintain had a mutual mistake which led to a series of events which gets us here today.
What was the mutual mistake?
There was an agreement to put out the
So it's August 31, 2020 that was crossed out and changed to September 30th, 2020?
It was supposed to be done in 4 places. It was done in 3 places. The failure to do the 4th one was the mistake.
And when was the premises? When were the premises vacated?
The My client has told me that the premises were vacated prior to September 30th.
Although the
Really?
records
By September
showing that
30th?
Things are going on beyond that date.
That is a claim, and that is disputed. Another thing that we have to start off with here is we're in the context of a motion for summary judgment. And there are a lot of disputes, but they all
But
rest
anyhow,
on the
paragraph
issue.
10 required that you
Excuse me?
vacate by August 31st, right?
That was the original.
And that wasn't changed. I mean, there's a different paragraph that's changed, which is, and I understand your point that it would seem that they obviously meant to change the other date, although that's contested, but what we're left with is in paragraph 10, the August 31st date. Now, you're, of course, arguing on behalf of the guarantor. How are you able to rely on defenses which are personal to the principal debtor?
Your Honor, at this point in time, the guarantor only guarantees debt. There's no question that the stipulation.
So you'd be home free if paragraph 10 had been switched to September 30th.
Yes, I believe so.
You'd be in good shape, but you don't have that.
That's the mistake.
So now what you've got to do is to make this claim, which it's the debtor, the principal debtor needs to be making, that there's this mistake in the contract. This is a scrivener's error. Does that claim, does that defense work for a guarantor?
If it was based upon a document that was not the guaranteed document, yes, it works for the guarantor, because the guarantor is not bound.
Doesn't the guarantee say you can't rely on these sorts of defenses? The fact that
But we're not dealing with a debt from the guarantee. We're dealing from a debt from the settlement.
Right.
And it's the settlement that led to the underlying
paragraph
debt.
8 is changed, but paragraph 10 isn't changed. And you want to latch on to say, which is a debtor's argument really, that paragraph 10 needs to be changed too, because its lack of change reflects a scrivener's error.
But
You rely on that.
But since what we're dealing with is a guarantee, that debt should have never been ratified by an ex parte application to the landlord-tenant court without notice to anybody.
So, counsel, I'm actually lost. I'm trying to follow you, but the guarantee says specifically at the bottom of record page 70, where paragraph 2 is quite long. It says that the approval of the guarantor is not required for a modification or an extension of the lease. So
But that's not what we have here, Your Honor. What we have here is a stipulation of settlement which waived all debt.
only if there was full compliance, and full compliance included moving out, vacating, surrendering, turning over the keys, providing notification to the landlord by a date certain. So you don't have that here.
Yes, we do, because that's where the question of fact is. We maintain that we were out by the September 30th date.
Who signed the stipulation of settlement?
The tenant.
So your beef is with the tenant, right?
The guarantee specifically states that the undersigned herein shall in no way be terminated, affected, or impaired by reason of any forbearances, settlements, or compromises between landlord and tenant.
But again, what we have here is a new debt. What we have here is effectively...
Why does it not constitute I thought it was a settlement.
It is a settlement, but what
But this
happens as
specifically
part of the settlement, Your Honor, there was a penalty provision. If you do not vacate by a certain date, you are penalized. Okay? The appellant here, did not sign on to that, but regardless, at this point in time, it changed the relationship. At that point in time, the debt was waived. We had a date that the tenant has to get out, And if the tenant did not get out,
But if
you're
we look-
penalized by having a
But if we
$500,000
look at the
debt.
plain reading of the guarantee states it shall in no way be terminated, affected, or impaired by reason of any forbearances, settlements, or compromises between landlord and tenant. So that seems to fit within that settlement or compromises between landlord and tenant.
And I would add,
Except, again,
Except what?
if it didn't result in a waiver of the fee and then a subsequent penalty, Your Honor would be correct.
so counsel, at record page 71, the guarantee says under a second page of paragraph 2 that all defenses are waived. All defenses available to a guarantor or surety are waived, whether the waive is specifically herein enumerated or not. So not only is the guarantor not a signatory to the settlement agreement, and is unable to really raise the defenses of the signatory to the agreement, but also, no matter what, this is like, I looked, but this is locked up. Every single little window, doorway, little hole, they're all blocked because this is an unconditional guarantee, isn't it?
If there was a debt.
If there was a debt.
Counsel, you read the settlement to mean that the arrears were waived?
That's what the settlement said.
Well, we'll see. But you read it to mean that the arrears are waived unless they don't get out by a date certain, and then they were going to be penalized with the arrears. As opposed to, you have to pay the arrears unless you leave by a date certain, and then we'll waive them.
I read it, the words is, the rent is waived.
Thank you.
May it please the court, Cheryl Ginsburg from Zingman and Associates on behalf of the...
Do you read it the same way?
No, I do not read it the same way. I think your honors really understand a lot of the case based on the questions. I want to point out in the stipulation, there was no new debt here. The tenant expressly agreed in the stipulation, the rent due through August 31st is a little bit over $500,000. That is owed. As consideration for the tenant leaving by August 31st, the landlord would have waived that rent. And then there was a penalty if they not.
And I think the language of paragraph 10 states that the waiver of legal fees and arrears is expressly conditioned upon the tenant's full compliance with this stipulation, including, but not limited to, tenant surrender of possession of the premises in according with paragraph 10 of this stipulation.
That's correct. And I want to point out in the stipulation also, the date was changed in paragraph 8, but it was not changed not only in paragraph 10, it wasn't changed in paragraph 11 either. So both of those dates that refer to waiver of arrears and monetary penalties both remained August 31st.
And you say that there was a reason for that.
There was a reason for that, and actually the only evidence of any negotiations between the parties that's in the record is an email from the tenant's counsel. It's reproduced at page 158 of the record. And in that email, counsel expressly stated, quote, given the further extension of the moratorium on evictions, I doubt the change has any significant meaning. And appellant counsel agreed that that particular change would not have significant meaning. However, a change in monetary terms would certainly have significant meaning. That would take away the entire consideration for the deal, waiving or getting a money judgment of $500,000 versus waiving all of that money. And yeah.
I'm sorry.
Sure.
So counsel, the stipulation is signed August 14th. And
Right.
according to paragraph 10, the date by which the tenant had to vacate was August 31st, and that would be, you do the subtraction for me, please, that's 7 days, I think. 31 minus 14, more or less.
About 15 days.
I can't subtract.
Right.
Okay, I'm really
half a month.
I can't do this. I can't do this in my head. Okay. Did the tenant at any point in time go to court, and this was a non-payment proceeding that was converted into a holdover proceeding? Did the tenant at any point go to court, do an order to show cause, and say to it would be the commercial landlord-tenant part, right?
Correct.
Say, oh, there was a mutual mistake.
Right. No, they did not.
And this is no good.
Right, they did not. And actually, prior to the vacate date, I actually had emailed tenants counsel saying your vacate date is coming up. Are you planning to leave? They said no. After the vacate date, I again emailed and said your vacate date is passed. We're planning to enter a money judgment here. And nothing was done. The tenant never went back to landlord-tenant court. The tenant never appealed. It was only once we tried to enforce that judgment against the guarantor, as we were able to do under this unconditional guarantee, that they said anything at all.
Was there any application for a stay of the execution of the warrant or a stay of anything?
No, no applications at all.
By the tenant?
Right, correct.
By anybody?
Correct, by anybody. The only thing that happened was the landlord asked the court to enter the money judgment in accordance with the stipulation.
And that was done?
Yes. Unless your honors have further questions, I rest on my papers.
Thank you.
Thank you.
Your Honors, again, unless you have any more questions, I think it's pretty well covered. I do believe, though, that the fact that it was the 14th to the 17 days is a very short amount of time. And it was clear to my client, at least in his head, and quite frankly also in mine, that the date was extended to September 30th, and there's the rub.
Thank you. Thank you both. Barash and McGarry, PC versus Edward Markowitz, or Markowitz.
Good afternoon, Your Honors. Brian Brick from Brick Law PLLC for the appellant, Mr. Markowitz. It is undisputed that Mr. Markowitz originated the Ferrioli case. Undisputed. The verified complaint puts this case in the context of a policy where the firm associate was compensated for bringing in matters to the firm. That's a common policy that a lot of firms have, to share some of the referral fees or some of the origination fees with an associate that brings a matter to the firm. And it's obvious why there are these policies. It's to incentivize associates to contribute to the business of the firm, and it's also to incentivize the associates to help increase their compensation. There is no claim in this case that Mr. Markowitz stole the Ferrioli case, that he diverted the Ferrioli case, or that there was anything else stolen from Barish and McGarry. This was a childhood referral that was only coming to Mr. Markowitz from the developments and the efforts that he had
How much
made.
money did he make off of this?
I believe the total referral was $140,000.
That's a lot of money for doing a favor for a friend, right?
It is.
And that takes away, I think that the question here that's posed, the test posed in Alexander is the corporate opportunity test. Did the law firm have an interest or tangible expectancy in the opportunity? And you're pointing out to a whole, it's not going to be a compensation plan, but a sharing policy. You bring in business, we share the benefit together. Here, the law firm lost out, right?
The law firm didn't lose out because it's not something that belonged to the law firm in the first place. And I'm glad Your Honor brought up the corporate opportunity doctrine, because that's really what controls. And for a procedural perspective, it's why we're here. It's because it's really the one thing that the lower court didn't do, and it was supposed to. We first moved for summary judgment, and as the court knows, there were competing motions that were not mirror image motions. We moved on the iteration of the duty of loyalty, as the plaintiff stated, as requiring all associates to bring in all fee-sharing opportunities to the firm. And that's simply not true. The reason why the corporate opportunity...
So what in the record supports defendant's claim that Mr. Ferrioli asked his financial advisor to contact the defendant so that he could refer the case to Weitz and Luxembourg? What is the evidence of that?
The reason why the record doesn't reflect that is because we moved strictly on the question of the duty of law that was stated in the complaint. We recognize, and it's why I just...
But now you're saying that there's an issue of fact.
Whether or not...
So the record is what you made it, and...
We were moving on the statement in the verified complaint that an associate has a legal duty under the duty of loyalty Otherwise, they are a faithless servant to bring all fee-sharing opportunities to the firm. And that's just not even close to the law. In every case, there's not one case out there where an associate who originated a matter is penalized for not bringing a case to the firm.
He had brought other cases to the firm, in fact, and had shared in fees.
He did, unrelated cases. And what is very important about the corporate opportunity doctrine is that we have to look at it on a case-by-case basis, each case, each time. And it's why, in a number of decisions where there are 15 or 20 matters being considered, the courts go through analysis of each one. They don't say, well, you referred one in the past, so therefore, every case going forward, we now have a legitimate, tangible expectancy.
He wasn't ignorant as to how the law firm handled referrals from the outside, right?
I'm sorry?
He wasn't ignorant. I mean, your client knew what was going on and what was expected of him.
Well, in terms of referring cases to the firm, that's not what was required at all. And in fact, it's a voluntary policy that if you refer business to the firm, we will share fees. There can't possibly...
If it was a voluntary policy, there'd be no reason to share cases and share fees. Better to get 100% than 50%.
The reason why these firms have these policies in the first place is precisely the recognition that they don't have legitimate expectancies and corporate opportunities in whatever the associate originates. It's to fill the gap. And that's why what you don't see in this is a breach of contract case, where what should be the case is if that's what the firm wants to have as a condition of employment, that has to be reflected in an employment contract. It isn't. So when you have a voluntary policy to compensate an associate who happens to decide to refer a matter, then that is on a one-time basis that referral. That can't possibly mean that the law firm, Barish and McGarry, or any other law firm, will have a tangible expectancy in some future referral that happens to come Mr. Markowitz's way that has no connection to Barish and McGarry.
But didn't he create a connection also, besides the fact that he was working there? Didn't he create a connection by using was it the letterhead or was it in the emails? What was it?
He referred the case on using his Barish McGarry email. And I want to point this out because I'm glad Your Honor focused on this. There is no use of firm assets to develop the opportunity. And this contrasts sharply to Weiss versus Verdone, where there was an actual use of the firm's resources to develop the business. Here, the development was already in existence. The origination was already in existence because Mr. Markowitz had done everything that had to happen for that case to come to him before he sent the email to refer the case.
Well, City Council, that's the issue. You move for summary judgment. So, I mean, the issue is whether there are issues of fact, and there seem to be issues of fact presented from your argument alone in terms of whether or not a law firm associate has a duty to refer potential cases to employer. You have affidavits from various individuals on the other side, including Mr. Lieberman, right, who opined on this. So, I mean, it's your motion to dismiss for a motion for summary judgment, but there seem to be issues of fact, and that's
Your Honor, they were
what we're
competing
presented
motions.
with.
You're right, and our motion focused on the lack of the duty, that there can't be a duty as a matter of law for an associate, and that's how it was stated in the verified complaint. That's what we moved on. There is no duty as a matter of law, as it was iterated by the plaintiff, to refer all cases to your firm. That is just so far from the law that that's why we moved. We completely agree that there are issues of fact on the generation of this case that come from whether or not the corporate opportunity doctrine is allowed to be extended to this case to find that they can recover as a matter of law affirmatively. That's very different than saying we can move summary judgment defensively because there's no duty how they've iterated it.
But where there may be no duty, no legal duty, the duty seems to be, there seems to be some type of contractual duty between the associate and the firm in terms of that was the understanding.
There isn't.
Was it not?
There isn't, and that's precisely the point. In order for that understanding to be there, and this is what is reflected in the cases, there has to be an employment agreement of some kind, and there wasn't here. This was merely, and moreover, on summary judgment, Barish and McGarry never even proved that there was this policy in the first place. They alleged that it was there, but what were the contours of it? What did it require? There's so much about this that doesn't even come close to showing how possibly can the Ferrioli case, which was only coming to Ed Markowitz because of his relationships having nothing to do with Barish and McGarry, how is that possibly a Barish and McGarry corporate opportunity? If that's the case, then think about all of the implications every time an associate refers someone to the person they like to do their wills, and that firm that they work at happens to have a wills department. They then are now a faithless servant.
How is it possible that they reach out to Mr. Markowitz and not reach out directly to someone that writes in Luxembourg, right? But anyhow, you have time on rebuttal.
Thank you, Your Honor.
Good afternoon. Dominic Penson for the respondent, Barish and McGarry.
Is it your position that when someone is employed, they can never refer cases out to anyone other than their employer?
That is not our position. The key here is profit. They cannot, an associate at a firm, and this is what this court held in Chung, an associate at a firm cannot refer a case for profit to another firm without the consent and approval of their employer. They can refer a case, or at least it's arguable, right? Because it doesn't have to be, profit can be defined any number of ways. It doesn't have to be necessarily money. There could be some other benefit involved. This issue is taken up nicely by the Texas Supreme Court case in that Johnson v. Brewer and Pritchard case that we cited in the papers. They talk about this. They say, we're not ready to say that an associate at a firm has to refer every case that comes along to their employer. But what we have no hesitation in saying is that they do have to get the consent and approval of their employer before they can refer a case to somebody else for their own profit. And that's the key. There's been a lot of talk in the papers, and I just heard some more talk about that it's undisputed that the case came to Mr. Markowitz through his contacts. There's no evidence of that. For all we know, it came to him because of the firm's reputation. The point is, it doesn't matter. That's what the court held in Chung. Justice Sherwood in Chung was confronted with the same argument. The associate there, Chung, argued that some of the cases came through his personal network, or they were cases that his employer, the Schweitzer firm, turned down. And Justice Sherwood said, doesn't matter. You were not free to take them for yourself or to direct them to somebody else, obviously for profit, without the express approval and consent of your employer. What there isn't, Mr. Markowitz argues that there's no case that supports what we're saying with respect to this duty, notwithstanding that the Chung case is directly on point. So is that Texas case, Johnson v. Brewer and Pritchard. What there isn't is a single case that stands for the proposition that he's advocating, that it's okay for an associate attorney to set up shop for himself while working full-time for a firm and collect referral fees without the consent and approval of his employer. That case doesn't exist, not in New York, not in the 50 states, not in the 12 circuits.
So is the duty of loyalty, is that a legal question, or is that a question left for facts for the record to be fleshed out?
On this record, there is no question of fact. The duty of loyalty is a common law duty that every employee owes to their employer. For a law firm associate employee, that duty includes the obligation to bring, that's what Chung held, that's what Johnson held, that it includes the obligation to bring to their employer any fee referral opportunities for profit, if that is a part of their employer's business. And here there's no question. In order to prevail under the faithless servant doctrine and the duty of liability, the only thing we have to show here is that he was an employee of the firm. A part of our business was to refer cases from time to time for profit to other firms, that such an opportunity came along, It did. That he referred the case somewhere and didn't get our consent and approval. If we can show those things, we are entitled under this doctrine to prevail.
Did I see something in the record that this was not the type of case that your firm would have handled?
That is an allegation that the appellant made. It is irrelevant. By way of example, again, if you look at that Johnson case, that was the Brewer and Pritchard firm was a securities transaction firm, and the case that the associate Cheng in that case ended up referring to Joe Jamail, or through somebody else to Joe Jamail, was a personal injury case. It doesn't matter. What matters is whether or not the referral or referring cases is an aspect of the employer's business.
And the fact of what the relationship between Lee Carlucci and the plaintiff may have been, it's your position doesn't matter. All of the factual matters around that doesn't matter because once there's for profit,
they're immaterial.
It doesn't matter.
It doesn't matter whether they're disputed. They are not material, so these are not questions of fact that should impede summary judgment as long as it can be shown that there was a referral for profit that was part of our business. He was an employee of the firm, and he didn't have our consent and approval to make the referral. How it came to him, the provenance of the case is irrelevant.
So I'm going to ask you a question that probably is academic. So if a friend did come to one of the associates at the firm and said, help, I need a referral, and the person said, sure, why don't you try this firm? Why don't you try this solo? Why don't you go to legal aid or legal services? You would have no issue because there would be no dollars there. Is that accurate, or am I overstating your
No. Actually, that is accurate, and that is very close to one of the examples that the Texas Supreme Court discussed in that Johnson case. There, what they posited was that an associated firm wants to refer their mother somewhere, and that we can all agree that the better public policy under those circumstances is that associate shouldn't be hampered, shouldn't be unable to refer their mother wherever they thought was the best place, as long as it doesn't involve profit. I would say to you that even if it's a close family member, if the referral involves profit, if I'm going to make money by sending my mother to another firm, then I have an obligation to get the consent and approval of my firm. But if I'm not going to make any money on it, then particularly given the importance of providing free client access to attorneys, as well as certain public policy considerations, I would agree with you. That would be fine. Unless there are any other questions, I will rest on the papers.
Thank you.
Thank you very much.
The requirement of having to refer cases and to get the consent of the firm has to be reflected in a contract, and it's not here. When Mr. Henson referred to the key as being for profit, so are we to understand that if an associate has a relationship and...
So, Counsel, I just want to ask you, what's the basis for that statement that it has to be reflected, the basis for your statement that it has to be reflected in the contract? Is that found in any case?
The basis is that the corporate opportunity doctrine exists. And if the corporate opportunity doctrine is to be taken seriously, then that means that we have to go through an analysis of each business opportunity, even for associates. And if there was no requirement...
Is an associate's duty towards the firm that employs him a matter of contract law, or is it a matter of agency and fiduciary duty?
Well, it's not fiduciary. It is agency.
The associate would not owe any fiduciary duty to the law firm?
No, and actually that's what the lower court specifically found when it rejected the fiduciary breach claim. It said that we differ from what Texas does and distinguished that this is a duty of loyalty, not a fiduciary breach.
Okay, so duty of loyalty.
But it still has to be, there are still limits to that duty of loyalty. The duty of loyalty, and this is what the lower court judge...
It's not really particularly a matter of contract.
Well, because it's where the duty of loyalty ends. The lower court judge said the duty of loyalty ends where you're not allowed to unfairly compete. Not that you're not allowed to compete. You're not allowed to unfairly compete. You can't misappropriate firm assets or resources, and you can't otherwise take illegal kickbacks. None of that happened. And there are cases that actually say it's perfectly fine for there to be prefatory business and setup. But I want to pose a few things to the court that are very important to distinguish here. First, the concept of it being for profit. Are we to understand that if there was a $1 billion class action that an associate happened to refer for no profit, that would be okay? That's absolute nonsense. All of the cases, especially the Chung case, here's what Chung did. Chung placed an ad using William Schweitzer and Associate money. The firm's money paid for the ad. After the ad was out there and running, the Chung associate, he changed the ad without his firm's knowledge.
Yeah, Counsel, I think we're familiar with Chung. Did you have a second statement that you wanted to make, or is your time? I think we're familiar with Chung.
Yes.
Is there a second statement you wanted to make, or is your time is up?
The only thing I want to say is that the concept of it having to be reflected in a contract, as the court said, is because that's where the limit of the duty loyalty is. And so the fact that the firm has this policy in the first place reflects that state of mind. They wouldn't need to have a policy if it was already a requirement that the associate had to bring all cases to the firm.
Thank you.
Thank you.
People v. Terrence Jones.
Good afternoon, Your Honors, and may it please the Court, Rebecca Martin for Appellant Terrence Jones. Your Honors, the Level 2 designation in this case was an overassessment of the risks Mr. Jones posed to the society at the time of the SORA hearing. To begin, he should not have been assessed points under Factor 12, and therefore should have started as—
So he was a presumptive 3. The court allowed a downward modification to a Level 2, but you wanted to go to a Level 1.
That's correct, Your Honor. And also, it is our position that he really shouldn't have been a presumptive level 3. It should have been a presumptive level 2 because he shouldn't have gotten points under Factor 12, which may have then influenced how far down they were willing to depart. To that Factor 12-point acceptance of responsibility, as with all factors, the burden is on the people to prove a lack of acceptance of responsibility. That said, I think it is notable that there was a fair amount of affirmative evidence of acceptance of responsibility. Mr. Jones accepted responsibility at Doc's Intank. He did all of this anti-violence programming and victim awareness programming, and all the letters talked about.
I thought there were letters submitted and that the defendant himself stated that he was not involved.
Your Honor, so there was a affidavit that Mr. Jones submitted. That affidavit was from his co-defendant. My understanding is that it was prepared in preparation of a prior 440. He did submit that to the board along with some other records. When he submitted that to the board, he was uncounseled, and I think that's important because he didn't include with that a letter saying, I'm saying that I agree with my co-defendant here. We have no real reason, no way to know exactly why he submitted that or exactly everything that he submitted, and because it was uncounseled, it may have been that he was just taking everything that he had on the case and giving it to the board. He didn't have, advice that the board might take this to mean that you are continuing to maintain your innocence. When you're looking at acceptance of responsibility, the guidelines and the case law all make it clear the focus should be on the most recent statements of acceptance of responsibility or lack thereof. Here we had his statements to parole, which were strong enough that he was granted discretionary release at his first opportunity. And then you also have the sex offender treatment that he began shortly before before the SORA hearing, and there the statements, the assessment said that he, and this is a quote, effortlessly adjusted and participated in the group.
Okay, so even if if in fact the points are not deducted under Factor 12, it doesn't really affect his risk level, right?
Well, yes, so then he would be a presumptive level 2 to begin with, and given the kind of many mitigating factors that he established by a preponderance of the evidence. Again, we have the programming and all of the personal growth there.
Programming is mostly anti-violence, right?
There's a lot of anti-violence and victim awareness programming.
And sexual offender treatment was one.
He did do sexual offender treatment. He began that shortly before his release.
He accrued disciplinary violations, right?
Sorry, can you repeat the
He
question?
accrued disciplinary.
He did have some disciplinary,
Some as in 11 Tier 3 and 13 Tier 2, so that would equal 24.
yes, Your Honor. Over the course of 25 years, though, and I would note that the board found that that wasn't even enough to be assessed points there, and also in the Compass assessment, he also got...
What you just said was very important, right? So the board didn't consider that that was enough to assess points, and that means it was considered.
Yes, that was considered...
So why should we give a further downward modification with something that was already considered by the instrument?
Well, you could think about that and answer on rebuttal.
Okay, thank you.
Good afternoon, may it please the court. Megan McLaughlin for the people. I just want to address a few things first and foremost. I think it's important to note that the defendant, while he did a fair amount of programming in prison, sex offender treatment was not one of them that he completed. He, as my adversary just pointed out, began that shortly before his release and actually began it only a week before the board's assessment of his risk. So in counsel's argument that the programming was one of many reasons, according to counsel, that there should be a further downward departure, the very treatment that...
Counsel, is that the reason why he only had a single note concerning the sex offender treatment program?
Presumably, yes, because it was the board only had a week's worth of information to go on because he began treatment for his sex offense just 1 week prior to his release. Now, according to defense below, the trial defense counsel's own assertions, that was due to a mistake that was on the part of the Department of Corrections. That does not change the fact that this defendant did not reap the benefits of sex offender treatment and therefore shouldn't be credited in any way for having done programming that would rehabilitate him in that way. Again, this is not a punitive measure. This was an assessment of this defendant's risk. And to that point, this defendant did not even receive the downward departure that the court did implement because his risk of reoffending was lower than the presumptive level 3 that he was assessed by the board. This downward departure was crafted by this SORA court in an attempt to mitigate any further risk that this defendant might present if he were to be tied to the restrictions of a level 3 offender. So the court made very clear in its downward departure decision that this defendant presented a high risk and in no way presented a low risk of reoffending, did not even present a moderate risk of reoffending, but because this defendant's, and I want to quote this, his risk would rise dramatically if he was assessed as a level 3 offender. The court felt that it was appropriate in this instance to downwardly depart to a level 2 so that this offender could go live with his wife in Florida and possibly reduce his risk in that way. And I will address the court's questions about the factor 12 points of assessment points. It's important to note that while it is the people's burden to prove that a defendant failed to accept responsibility, accepting responsibility is an affirmative act. So the people only would have had to have proven that the defendant did not accept responsibility. The people did not have to prove that he affirmatively rejected responsibility. So even notwithstanding the fact that this defendant actually sent the board a statement denying his involvement at all in the crime, even aside from that, this defendant SORA court was presented with evidence that the defendant had maintained his innocence through trial, had refused to be interviewed by probation upon his conviction, appealed his conviction, applied for a leave to appeal for that conviction, and made various legal challenges, including his own 440 motions after this. So in no way should this court find that because possibly the SORA court disregarded I think the court said something to the effect of, just for argument's sake, if we didn't consider that 440 motion, it's very clear from the facts of this case that this defendant did not accept responsibility for the sex offense and was appropriately assessed 10 points for that, and in the people's position was underassessed in that way.
Thank you.
Thank you.
Your Honors, I would argue that that was a misrepresentation of the reasoning behind giving the downward departure. Rather, what the court recognized was that Mr. Jones had a very strong community in Florida, that is, a strong community, a job, a house. These are all things that reduce risk, and that if he was a level 3, he might be torn away from that community, which would, if you take away the mitigating factors from someone, then they will no longer be mitigating factors. So I think that would be the way to think about
Be
it.
able to travel to Florida?
Mr. Jones is now living in Florida.
I beg your pardon?
Mr. Jones is now living in Florida.
He is in Florida
yes,
right
he has
now.
moved to Florida
Ah.
and living with, my understanding is he's living with his wife as. So that was a good outcome. To go back to the question of whether something had already been considered, I would look at the conduct while incarcerated. They considered, the disciplinary actions and whether or not that was enough to amount to points, but that is not the same as considering the exemplary participation in programming. And my time is up, so I will rest on my papers.
Thank you. Thank you both. Last case for argument, Bellaro versus Lato.
May it please the court, good afternoon. My name is Jan Marcus. I represent the appellant. We have a situation here which presents some odd facts, as much as the record has been fleshed out so far, and some curious behavior on the...
So at some point, there was supposed to be water meter readings in order to, there was supposed to be water meter readings in order to go to closing, and because there's changes being made with the meters, the seller can't come up with those meter readings, and the suggestion, let's put it off, as set forth in the facts. But your client takes the position, well, you're not able to close, you're not able to do what you're supposed to do in order to close, and therefore the contract is terminated.
Correct.
How do you turn around and say, I want specific performance now?
That's why I started with this is an odd situation. You have to look at the totality of what happened here. So if you have a situation which I have not seen in cases before, maybe the court has, I have not, where the seller ignores the fact that the buyer is saying the contract is terminated.
Right, but then there were several closing dates after that, and the buyer did not show up for that either.
The seller unilaterally set those closing dates, unilaterally canceled them, and each time counsel for the buyer said, we're not closing. This contract is terminated. Give us back our money on the incidental expenses. It's ignored. It's ignored each time by the seller.
So does that, the fact that it's ignored means that the contract comes back to life?
I don't think so. What I think happened here...
The money is in escrow, so you can try to get it back through negotiation, or maybe you have to start litigation.
Now, that may be one issue on the part of the buyer. Should the buyer have done more to vindicate its rights here? But what the seller did, and it's important because of the provision in the contract, 13.05, that says if the seller willfully, not an unusual provision, if the seller willfully defaults, that gives the buyer a contractual right to specific performance. However, that call can't be made, and this is where the appellant says was the error in the trial court. That can't be made unless you have a more fully developed factual record. So the reason and the motivation of the seller to ignore continually the claims that this contract had terminated, and then goes on and tries to set closings, and also curiously, because only the owner could deal with the city to have these meters put back in, there's never any evidence of how much of an effort the seller put into that. The seller then convenes a closing and knows the buyer isn't going to show up, and then turns, I'm sorry.
Counsel, can I interrupt you a minute? Because we're familiar with the trajectory of the fact, the trajectory of the case, the appeal. I want to ask you a question that goes to whether the contract is null and void, okay? So we know that the buyer could terminate the contract upon giving a notice of termination and saying, I'm done with you, right? But if you look at paragraph 13.07, which is found on record 212, it says that upon the giving of the termination notice and seller's refund of the down payment, this contract shall be null and void, and the parties hereto shall be relieved of all further obligations and liability other than those arising under sections 14 and 1704. So since there's been no refund of the down payment, as far as we know, but you did give the termination notice, is the contract null and void?
If there were a return of the, I'm going to answer it this way, Your Honor. If there were a return of the deposit, then obviously that would end it. The fact that the seller ignored this and did not abide by the notice by the buyer continually that the contract had terminated, it has to be null and void no matter what the seller did. It has to be, because the buyer is saying you can't provide us with good title.
I don't know.
We're invoking that. We're telling you.
You're saying that the contract is null and void?
Yes.
Okay.
Thank you.
Thank you.
Thank you.
Is the contract null and void?
Contract was terminated.
But you didn't give.
Contract was terminated by the buyer.
But you didn't give the down payment back.
I'm sorry?
But you didn't give the down payment back.
We didn't terminate the contract, the buyer did. We didn't feel that the termination was proper. Therefore, the down payment is still being held in escrow and the subject of further litigation before Judge Gomez in Bronx Supreme Court. So the buyer, the appellant, still has other causes of action that survive this motion for summary judgment that was granted by Judge Gomez. What's lacking on the part of the appellant with respect to the position that they took and they're taking now is there's been no willful default by the seller. Consistently, the buyer and the buyer's attorneys, two of them, state that the seller was unable to provide the meter reading. The seller had an inability to provide the meter reading. There's never an allegation before the complaint is filed of willful default. That's an important fact. And in addition, there were two separate closings after the water meter reading is in hand. There are two separate closings that were scheduled. One was an initial closing. The second was a time of the essence closing. The purchaser, the appellant's attorney, had the title meter readings in hand at that time and still claimed that, no, we terminated the contract. We're not appearing for the closing. They never appeared for any of the closings. They never demonstrated the fact that they were ready, willing, and able. They weren't. Their position was, we terminated the contract. They did it improperly. They did it in default of the terms of the contract. We set the closing date. They failed to appear. The funds are still being held in escrow by the escrow agent, and as I stated, will be the subject of further litigation before Judge Gomez. But with respect to the claim for specific performance, there were two separate opportunities for the appellant to close with the title meter reading in hand, which they claimed was the title defect. What's also important, it's in the record as well, is that my clients were going to remain in the premises for a period of 6 months under a rental agreement after the closing and pay all water charges. So Why was the water bill an issue?
So I saw an exhibit where the water bill seemed to be a very small amount of money. Was the water bill, is there anywhere in the record where it says how much the water bill really was?
The actual water readings are provided in the record, and they were not a substantial amount of money. That's true. In addition, as I stated, my clients were going to continue in possession for 6 months after the closing anyway and pay all water charges. It was part of
Usually
the
what would
agreement.
have happened here is that there would have been some evaluation of what the water charges would be. Money would have been left in escrow
Yes.
until there could have been a reading, but
Your Honor, absolutely right. And that was even offered, it's in the record, it was offered by my client's real estate attorney to put money in escrow and close. And they did that early. The
I
original
mean,
offer-
I know it's not determinative of the legal issues, but what seems to be at play here is this is happening just as COVID is in its worst in 2020, and probably the property value is falling, and then as things ameliorate, property value is going back up. So that's probably the background to it, but that's...
May very
it's
well
not-
be.
it's not the
It's not
controlling-
necessary for an actual determination with respect to the motion before Judge Gomez.
Nor should it determine the motion.
Pardon me?
Nor should it determine the motion. It's just...
Right.
Just explains the background of what's going on.
There is an administrative matter that I do have to put before the court, and that's with respect to the incomplete record. I do have to move to dismiss the appeal on the basis of the fact that the appellant did not provide a complete record on appeal.
You weren't really prejudiced by that, were you?
I'm sorry?
You're not prejudiced by that omission, are you?
The affidavit that was left out was actually my client's affidavit in support of the motion for summary judgment. So we
It
would
doesn't
like,
prejudice you on the appeal, does it?
doesn't prejudice me on the appeal, Your Honor. No, it does not. Otherwise, we do rely on the brief that we filed, and we thank you for your time. Thank you.
Thank you.
Yes, may it please the court, I'll see how fast I can talk. The original termination of the contract occurred in March. Closing was supposed to be in February. And that was in response to the seller's attorney saying, New York City has to come in and do these things with the meters. And the buyer said, that could take a year. We don't want to wait that long. We're gonna have to terminate. You can't do it. It's past the closing date. And that's what was continually ignored. As far as the record is concerned, an affidavit was inadvertently left out of the record. There was no reason to purposely leave it out. If it's inadvertent, I can't find that out until I see it in the brief from the respondent. And quite honestly, as I said in the reply brief, we'd be willing to, of course, add it, but the argument came up so fast after the reply brief, I didn't get a chance to do that. But, and I agree with Your Honor, there's no prejudice to the plaintiff. It's the owner of the plaintiff. It was accidental. There was no reason to not provide a full record to the court. Thank you.
Thank you. Thank you both.
Thank you, sir. All that prep for...